Yeah, I hate that word. Can't figure out how to lift it up.
He told me the name off.
Another speedy trial demand? Really?
Judge.
It's probably gonna go to Emerson. You asked for it.
What's the trial we're getting ready for him, do you know?
Yes, and the email just went out to all the judges. It's the last week in January. So what is that? The week of the 26th. Uh-huh. Okay, let's get started. So for scheduling purposes, we're going to go till 10 to go swear in yet more new lawyers virtually. Then we'll be back 10:20-ish. We can go until about noon if we don't cover everything from the morning calendars. There was an add-on, and I think we're picking up 2 competency docket pleas. Our business will take precedence. But we have a 1 o'clock calendar as well. So if there are things we don't finish this morning, we can tackle them in the afternoon. I'm also presiding, so we may pause from time to time between cases if people walk in. Did you want, Ms. Niles asked, did you want her out here so you don't mind going back there? Okay, all right, great. Then let's get started. We have a final plea calendar. Most of the cases on the final plea calendar are on our January 7th trial calendar. That's right. We're going to hit the ground running in 2026. When people come back, we are calling a criminal trial calendar on the 7th. And so cases that don't resolve today on the final plea calendar will roll over to that January 7 calendar. And the first 4 positions are Ms. Madden's. I think, Ms. Madden, you're on.
Good morning, Judge. How are you?
I am well. Let me get you on the screen there. We'll add you to the spotlight. The podium is on. And my understanding, Ms. Madden, is that Mr. Beck is having a medical procedure today. It's outpatient. He's okay. He'll get it treated. He'll get you documentation that that's where he was today. And we are moving his 4, not 1 or 2, but 4 cases to the trial calendar, preserving his final plea rights.
That is all I was going to ask, Judge. So yes, that is correct.
Okay. I'm going to ask, are he's likely?
We do have a
Ms.
recommendation from the state, a global recommendation that was resolve all of his cases. I have talked to him about that. It does involve a substantial amount of jail time. I mean, he's mulling it over. I probably will have a counter to the state, but it may be a non-negotiated plea anyway.
Okay. Ms. Smith, welcome back. Glad you came back. If you could be thinking between now and the 7th, which of the 4 cases you'd go out on. Because if Mr. Beck declines your offer and actually is not interested in a negotiated plea, then I'll probably be interested. This would resolve 4 cases. If we go to trial on 1, it'll probably resolve all 4. And you get a pick which of the 4. So in preparing the 4, just prioritize whichever one you'd want to try first. And letting Ms. Madden know will help her as well. And so far, she's got to get ready for a trial if that's how it's going to play out. So Ms. Madden, we will see you and Mr. Beck in person on the 7th. If between now and then, and I recognize it's mostly holiday time anyway, but between now and then you sort something out, let Ms. Nelson know, and we can always get everyone in here and resolve it and take it off that calendar for the 7th.
Okay, Judge, sounds good. Merry Christmas if I don't see you.
Same to you. Take care.
All right, thank you. Bye-bye.
All right, that gets us to Kendrick Brightwell. And I think, Ms. Rios, you had asked if he could not be here But hopefully word got to you so you could get it to him that he needed to be here.
Texted me and said traffic was bad. So
Okay.
introducing-
But he's doing his best to get here.
Yes.
Let me look that up again. Yeah, okay. Let me know when he gets here. Layla Faria? I'm sorry if I mispronounced your last name. Good morning. We're waiting on your lawyer. Ms. Cabrera will be here. I think she's in Cobb. She's got several cases this morning. So she'll be, have you and she met? But you've talked? Okay. So she'll be here and we'll figure out what's happening with your case. Ms. Smith, have you and Ms. Cabrera talked about, how do you pronounce your last name? Faria. Have you and Ms. Cabrera talked about Ms. Faria's case?
Yes, we did.
Okay. Is your sense it's resolving today or she didn't get back to you on that?
I don't think it will be resolving today. We'll be doing something else before the trial calendar with the defendant.
Something else. Okay. All right. Aziz Lewis.
He would be mine, but if he shows up, I don't.
Okay. And then he told you, or you've had trouble reaching him, or?
Go contact him in the sense of thinks there's other matters, or knows there's other matters out there.
That would deter him from being here, or that would have him be stuck somewhere else?
Deter.
Okay. Ms. Faria, do you happen to know Mr. Lewis? Okay. Any idea where he is? Not at the, well, me neither at the moment, but like yesterday, did you know where he was? Okay. All right. Mr. Gates has been further noticed to the 7th for the trial calendar, preserving his final plea rights. He is, I think, in Clayton County Jail. He's locked up somewhere, and his lawyer reads Clayton.
Yeah, he picked up on the
Okay. Could you send me an email, whatever information you have, if you have a case number or what the charges are? I'd like to revoke his bond here. And that if I can just say, hey, he was arrested on case 1234 out of Clayton, whatever you got. Thanks. But Ms. Smith, Mr. Gates will be produced for the 7th. We'll preserve his final plea rights. Just looking at these charges, it should be work outable. I don't know his attorney, but hopefully you and he can talk. How have you been?
I'm sorry.
How,
Pour a bunch of that in there. I
How-
poured some, yeah.
how have you been?
Oh, I've been good.
Good.
What about you?
Been busy. Life was complicated this weekend. All right, Raheem Smith. I see his lawyer.
We're good.
Hey, Mr. Melnick.
He's on the Zoom call.
He's on the Zoom call. There he is. There he is. Hello, Mr. Smith.
Hi, I'm fine.
Where are you calling us from?
The same address.
You at home?
Yeah, I'm at home. Yes.
Okay.
Yes, ma'am.
Great. So, Mr. Melnick, this is final plea day for Mr. Smith. Let's get on the record for this. Good morning, Ms. Rivers.
Good morning, Judge. How are you?
I'm well. You ready to go?
Yes, I'm ready.
Okay. This is 25 SC 003-451. Mr. Smith is appearing virtually. His lawyer, Mr. Melnick, is here in court. We've got Ms. Smith, a different Smith, for the state. Mr. Melnick, do you feel like you've got all the discovery in the case?
I do, yes.
Okay. And you received, hopefully before last night, an offer from Ms. Smith?
Yes, well, I have. I've discussed it with Mr. Smith.
Okay. Is that something Mr. Smith is interested in going forward with?
Judge, so you can probably see on your calendar, this is one of about, it's a 5-defendant.
Right, this case, we're about to get into it, right?
Yeah.
Okay.
And so there's a minimum mandatory on the kidnapping charge that the state has not agreed to come off of. And so we're not in a position to resolve the case today.
Okay, well, let's get the offer on the record. I'll ask your client a few questions and then we can further notice it to trial. Ms. Smith, if Mr. Smith were going to enter a plea today, let me know what the state's offer is, please.
Yes, Your Honor, for counts 1 through 4, the recommendation was 10 years to serve, to run concurrent. Count 5, 12 months probation, and count 6, 5 years probation, for a total of 15, serve 10, balance probated.
All right. Mr. Smith, do you understand what the state's offer is in this case?
Yes, Your Honor.
If you were to enter a plea, and with a mandatory minimum, Mr. Melnick, despite his impressive advocacy skills, couldn't get you below that mandatory minimum. So it sounds like the state's basically offering you the minimum unless they dismiss or reduce a charge. But the state's recommendation would be 10 years in custody, followed by 5 years on probation. You understand that?
Yes, Your Honor.
Okay. Is that something you are interested in pursuing at this time?
No, Your Honor.
Okay. Then what I'm going to do, Mr. Smith, is move your case to our January trial calendar. You will need to be here in person on January 7th for the call of the calendar. Mr. Melnick will be here and we'll figure out, did something change between then and now and we've worked it out? Or is this the case that we'll end up trying? The trial doesn't start that day. That's when we figure out what we are going to try. But you'll need to be here on that day, not on Zoom, okay?
Yes, Your Honor. No problem.
All right, Mr. Melnick, anything else we need to cover on your client's behalf?
Not on this case, Judge. I'm going to speak with Ms. Smith this morning.
Okay, sounds good. Does Mr. Smith need to stay on?
I can get in touch with
You
him.
can get in touch with him? All right, Mr. Smith, questions about anything?
No, Your Honor.
Okay, well, stay in touch with your lawyer. Have a safe holiday.
All right. Thank you. You have a great holiday too. Thank you so much.
You bet. Tyrone Patterson. Good morning. Ms. Rios, are we in a similar posture?
Yes, Your Honor.
Mr. Patterson, I need you to come on up to the podium, please. Good morning again. Let's get on the record. Your case is the same case number. It's 25 SC 003451. Your lawyer, Ms. Rios, is here in court with you. Ms. Smith is still here in court. Ms. Rios, do you think you've got all the discovery in the case?
I believe so. There was some added that I'm still going through, but
There's some what?
there was some new discovery added to evidence.com link that I'm still going through.
Okay, but nothing's jumping out at you. Wait, they say my client gave a statement. I don't have that. As far as you know, you've got everything.
Yes.
Okay. Ms. Smith, is the state's offer to Mr. Patterson the same as it was to Raheem Smith?
Yes, Your Honor, this defendant has an additional count 7, that is 10 years to serve, but it is going to run concurrent with counts 1 through 4, ending up with that same sentence, 15, serve 10.
Got it. So, Mr. Patterson, if you were interested in resolving your case today, the state would require you to plead to all the counts in the indictment, and one of those includes a mandatory minimum. And so Ms. Rios really wouldn't be able to argue for a lesser sentence. I guess you could shrink the probation or something, although I think that has to be 5 years. So what you would be looking at is 10 years in custody followed by 5 years on probation. Do you understand that?
Yes, sir.
Is that something you're interested in pursuing today?
No, sir.
All right. Then what we'll do, Mr. Patterson, just like I did with Mr. Smith, is move your case to the trial calendar. You'll need to be here, this courtroom, same time, 9 a.m. on January 7th. And that's the day we'll figure out what case is going to trial, what's not. It's looking like this one may, if nothing shifts with the state's offer or your preference about how to resolve it. And that's fine. And we'll just have a trial in January. But you'll need to make sure you're here on the 7th and certainly stay in touch with Ms. Rios between now and then, okay?
Yes, sir.
Any questions?
No, sir.
All right. Anything else, Ms. Rios, on behalf of Mr. Patterson?
Your Honor.
All right. You're good to go.
All right, thank you.
Let's see, we'll start, yeah.
Amaya Harrigan. Ms. Harrigan? Oh, I didn't print it out. I don't have it. Give me a second. That's not it. Harrigan. Okay. She's supposed to be here, and so is Ms. Cabrera. And the notes I have, Ms. Smith, is that Ms. Harrigan is actually working this case out. Is that news to you?
Yes.
Okay. Well, we'll find out. She's got to be here for it to be a plea. Shanika Francis.
Good morning, Your Honor. Attorney Brown Melcher here, and Ms. Francis is on the Zoom call as well.
Good morning, Your Honor.
Morning. Let's get everyone on the screen. There we are. Okay. Got it. Investigator Sajak, it's two different cases?
Yes, sir.
Okay, thanks. Ms. Brown Melchior, is the offer that your clients received the same that we've heard for the others, or is it something different?
That's correct. It's the same offer, Your Honor.
Okay. And do you, from your review of discovery, do you feel like you've received everything that's within the state's span of control?
Yes, I do.
All right. So Ms. Francis, it sounds like right now the state's offer to resolve this case would involve you pleading to the indictment, where one of the counts has a mandatory minimum, and the state's recommendation would be 10 years in custody, followed by 5 years on probation. Do you understand that?
Yes, Your Honor.
Okay. Is that something you are interested in pursuing?
No, Your Honor.
Okay. Then, like the other defendants that I've chatted with this morning, we will move your case to that January 7th trial calendar. The two of you, lawyer and client, will need to be here in court for that calendar call in case somehow it's being resolved, and if not, so we can talk about the specifics of how we try this case. If this is the case that goes out, we may need to go to a different courtroom so that we can fit everyone in the courtroom. So we'll need to talk about logistics, things like that. And I need to remind myself as to when, so the trial calendar starts on the 12th. So the trial would start on the 12th. We would call the calendar on the 7th. And if this is the case going out, then Monday the 12th is when we would do, most likely when we would do jury selection.
And Your Honor, just to put on the record, Mr. Adams is also on this case. He has emergency leave. He lost a family member, so he'll be out of the country on the week of the 12th. So we are going to file that, but I wanted to give the court notice. We are free and available for the next trial calendar in February if you have one, but I did want to let the court know that.
Well, first, I'm sorry for Mr. Adams's loss. Let me pull this up.
Excuse me.
So the only entry of appearance that I've got is, it's the firm of Keith Adams. Oh, I guess his name is sort of under there. You're the one who signed it. So you and Mr. Adams are co-counsel on this?
Yes, Your Honor.
All right. And you are thinking that if we go forward on the 12th of January, you would want Mr. Adams to be there? It wouldn't be something that you would do solo?
That is correct, Your Honor.
All right.
He's fine. He's just.
He will be filing the leave of absence soon?
Yes, Your Honor. We will file that emergency leave today.
Okay. All right. If you could send a courtesy copy of that to Ms. Nelson, that'll help me remember it. And we'll see what we do with that.
Yes, Your Honor.
Anything else on behalf of Ms. Francis?
No, Your Honor. And I will appear on that January 7th in-person call of the calendar date.
Great. When is Mr. Adams supposed to be back?
I will ask him. I know he's out the week of the 12th. His flight leaves on the 12th. He'll be going to St. Thomas. That's where the memorial service is. And then I would assume he would be back by the end of the week.
Okay, got it. We'll let him know we're sorry for his family's loss. I'll look for that emergency leave, and we will certainly see you and Ms. Francis here in court on the 7th.
Yes, Your Honor. Thank you.
Ms. Francis, do you have any questions?
No, sir.
Okay, thank you.
All right, thank you. Merry Christmas.
You too.
Thanks.
And final defendant in the case is Mr. Bradford. And I think, Mr. Luemba, you let us know. Good morning. Oh, he made it.
Yeah, he made it.
Wow. All right. Impressive. Why don't you guys come on up to the podium, please?
We approach on Mr. Bradford, judge myself in the state.
You can. I'm gonna get through the rest of the calendar. There are only a few more positions and then we'll talk. So Mr. Bradford, take a seat and then we'll talk. Silas Baker, he should be in custody. And we're waiting on Ms. Cabrera on that one. And I'm told, Ms. Smith, that that's a plea also. Is that news to you too?
Yes, Your Honor.
Okay, you look pained. Plea is a good thing.
It's not a problem.
Okay. Okay. And maybe it's not a plea. We'll see.
Well, I informed Mr. Burr yesterday.
Okay. Calvin Ross,
He is my client judge.
and he's here.
Yes, I'm expecting a plea today. I just need to speak with Ms. Smith and Mr. Ross once more before we do it.
Okay. Well, I will sit tight. We can do that whenever. So if I go back over the calendar, Mr. Beck is, he's just going to the 7th. Mr. Brightwell is here. Good morning, Mr. Brightwell.
Good morning, how you doing?
I'm doing okay.
Sorry.
That's okay. So Ms. Rios, do you need to chat with him?
I think we're ready on a negotiated plea.
A negotiated plea. Okay, great. And then Ms. Faria, we're waiting on Ms. Cabrera. She is going to be here, and then we can talk about your case. Mr. Lewis is a bench warrant, Mr. Gates further notice, and then we went through. So Ms. Harrigan is the one we're waiting on. Okay. I need to have a quick conversation with Mr. Luemba and Ms. Smith. I need to have a quick conversation with Ms. Simpson about Mr. Akins's situation, and then a conversation with Deputy Gordon. So nice shoes. Why don't Ms. Smith, you and Mr. Luemba, is it a long conversation? No? Okay, why don't we just go in the back hallway? And then I'll come back out to talk about Mr. Akins's situation.
That the one is put. Oh, yeah. Yeah. Okay. Right, whatever. How are you? Did your client stab? Yes. I think that was the one you said stabbed him.
No.
Maybe it was Cordelia. I think it was where he said, one of y'all.
So my client is only alleged.
No, stabbed, not the victim, the client.
Right.
Yeah, but apparently he said he was stabbed.
Which one? Your client is.
Patterson, Edwin Patterson.
Really?
Yes.
Like in a totally separate instance?
Yeah, totally after his case was indicted.
So my client doesn't have any other cases.
Okay.
Uh,
No, I
See, my guy's got like no record at all,
Mhm.
you know?
Yeah.
I think the kidnapping is incidental to the offenses, you know?
Well, it seems like he came there to get paid.
Right.
Because it wasn't that they picked him from condominium.
That's
or he came
exactly
from It's like a couple fight and food.
Mhm.
But you don't think that his sister did.
Mhm. I
So
know.
I'm wondering.
My understanding is
Yeah.
you know, yeah, so he didn't report it to police at all.
Yeah.
His sisters reported it to police.
Yeah.
You know, but they're really strong on these witnesses and to testify. So I don't think that's something that we can count on. My guy's not alleged to have done that.
Yeah.
So, yeah, but that's weird. So your client says that my client might have stabbed him. Like at the jail?
No, not even after jail, like after, like I called him and didn't put that on staff. Yeah, but maybe it wasn't him, maybe it was someone else.
Yeah. That's like this kind of laid back. It's from the version.
Oh, okay, yeah.
That's like violence is not part of it. So then Brian is she instigated.
Yeah. But everything, it was all on her behalf.
Like, I don't like anybody that much.
Yeah, no, I really don't understand it.
I don't either. But I think we can get it. I don't know if we're gonna go probation.
Yeah.
You know, but I think.
Is your client saying that it's
And my client offering.
information, saying,
Yeah, no, he's
just
not.
saying it wasn't there.
So, well, according to the report, for whatever it's worth.
I shouldn't be too long.
The victim doesn't claim that my guy had a gun. He claims it was Tyrone and I think Kadir
Yeah.
that pistol whipped him. One of Kadir's involvement is.
They're saying that he pointed the gun.
Right, but like, that's related to Shadir.
I don't know, because I know it's her, he's just a friend. Yeah, so I think it may be
Again,
just a friend who
It's
were
not
just
something
at
my
the
friends
house.
asked me to do. So.
My understanding is that he was abusive, but that was her ex-boyfriend who was physically abusive.
Yeah.
Yeah.
Right. And then, yeah, so.
Thank
Look at
you.
that January 12th. There's like a couple of murder cases.
Yeah, but one of the murders is pro se.
Oh, really?
So, yeah, he was mine and he wanted to file all these motions and stuff. And I was like, I'm not doing that. It's like, oh, I'll just do it myself. So he's pro se, so I'm not sure. He's filing stuff, so he's been pushed back a couple of times.
Yeah,
I'm waiting on.
gotcha.
We'll see.
All right, Mr. Bradford, if you could come on up, please. Good morning.
Good morning.
So what we're going to do is move your case like your co-defendants to January 7th. You'll need to be here in person with Mr. Luemba. I'm going to preserve your final plea rights. Mr. Luemba, help me understand why that makes sense. So you and he can keep talking, and then he can keep talking with the prosecutor. And that means that if on the 7th, for whatever reason, you all are trying to work the case out, you'd have the ability to withdraw your plea if you were unhappy with the outcome. Okay? Any questions about any of that? Okay. So between now and then, stay in touch with Mr. Luemba. He'll want to be talking to you, and I'll see you in person on the 7th. All right. Any questions?
No question.
All right. Thanks.
And Judge, that concludes my business. May I be excused?
Yes, sir.
Thank you, Judge.
Do we have a shorter plea that we could fit in, or should we just do the pleas after swearing in because people want to touch base with Ms. Smith?
I'm ready to go on Kendrick unless she has people that she needs to talk to. I don't think it's gonna be a long plea.
We can do Kendrick now.
Let's do that. Mr. Brightwell, come on up. What do we need to do with Mr. Akins? Is there something I need to set aside?
Good morning. You look nice.
My notes here is that some judge, magistrate judge had,
They brought back a warrant that was already done.
okay,
Actually already,
resolved.
it's not resolved, but it's already done, first appearance and all of that.
Yeah, like he hasn't missed court or anything like that.
And then, he needs his special condition modified that, he's not reporting while in drug court.
Got it. Okay. All right, well, let's get on the record. This is position 5 from our final plea calendar, 25 SC 002-688, State versus Kendrick Brightwell. He is here in court with his lawyer, Ms. Rios. Ms. Smith is handling the case for the state. And Mr. Brightwell, in just a moment, Ms. Smith's going to put you under oath and then ask you a bunch of questions about your rights and about the case. You need to answer those truthfully. If at any point you've got a question because you're confused by something or just curious, will you let me know?
Yes, sir.
All right, Ms. Smith.
Mr. Brightwell, can you raise your right hand? Swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Lord, your name. Can you say the truth, correct, and legal name for the court?
Kendrick Brightwell.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone to school?
22. I graduated high school.
Where'd you go to high school?
South Atlanta High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead guilty, or if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Ms. Smith, is the microphone in front of you?
Oh, it's actually pointing up at the ceiling. Here it
Can you
comes.
hear me now?
Yes, thank you.
Sorry about that. Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No, I'm sorry. I apologize.
That's good. And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Okay, do you waive the formal reading of the indictment, counselor?
Yes.
Mr. Brightwell, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
I apologize, ma'am.
You're good. The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
We do need to work through, the system shows there's a warrant, not in connection with this case.
Yes, so that was the same issue last time, and I think we found that it wasn't active, and he's called around to different police stations to figure out what's going on. They always tell him there was no charges taken out. I can't find a misdemeanor case number or I've looked and I can't find anything.
Okay, I mean, I've got the warrant number, so I don't know if you can look it up by number or how that works.
I could. Can you print it up?
Print the warrant out?
Yeah.
If I can find, I'll click on it. I don't know what's gonna happen. I mean, it's not gonna blow up, but I don't.
I could just run the day and.
think I found, no, I'm not authorized to view it. It's from March of this year. You just want to run his name? What's the easiest? Okay, all right. But it's not related to this case. So the answer is there are no warrants in connection with this case.
Mr. Brightwell, do you understand that you are entering a guilty plea to the following offenses? Count 1, aggravated assault, and count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies.
Yes.
Do you understand that today we're going to be entering a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
Make sure you speak up.
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am. Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including in a federal case?
Yes, ma'am.
And are you currently on probation?
No, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Yes.
And for example, that means that your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
And do you understand that this is true even if you're pleading under first offender?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
And do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that the federal government considers a first offender plea a conviction for the purpose of deportation and can still affect your ability to remain?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading guilty to these charges?
Yes.
Mr. Brightwell, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you've decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment 25 SC 002688, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm or knife during commission of or attempt to commit certain felonies.
Guilty on the F.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is an error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
And do you understand that that discretionary appeal must be completed within 30 days of today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, if this case would have gone to trial, the state would have been able to prove that on December 24th, 2023, Atlanta Police Department Officer J.E. Whitehead responded to a family dispute at 2400 Campbellton Road, Southwest Atlanta. Upon arrival, the officer spoke with the victim, Akira Willis, who stated that her cousin, the defendant Kendrick Brightwell, came to her place and pointed a firearm to her face. The victim explained that the defendant arrived at the location upset with the victim after she revealed some personal things about him on Instagram. The defendant came into the room that the victim was in and pointed a gun to her face and stated, "Why the hell did you tell everyone I have herpes?" The victim asked the defendant if he was going to shoot her, and then the defendant struck her in the face with a firearm. The defendant and victim then went back and forth for a while before the defendant fled the location. The officers did observe a laceration on the victim's earlobe that was bleeding at the time that they arrived to the scene. At that point, the officers obtained arrest warrants for the defendant for aggravated assault. And those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to, for count 1, 5 years probation, and also for count 2, 5 years probation to run consecutive but suspended.
Okay.
For this case, Your Honor, just to let the court know, we did have a chance to speak with the victim and she voiced her opinion about the defendant, who is her cousin, to not have to serve jail time because he has kids. Just shared her wishes with the court. So we did go back and forth a while about the plea negotiations. However, we did end up on the plea I just told you about, which was the 5
Okay.
probation.
And how are you wanting the sentence to reflect Mr. Brightwell's ability to have contact with I have Ms. Williams. You said Willis, but same person?
Willis is her name, her last name.
Oh, I was just, he was saying that because he wants to have contact with his cousin. I was just telling him that the offered conditions was no violent contact.
Yes, Your
So
Honor.
it is contact, just no violent contact.
Yes, we
Okay.
also have some other special.
Great, I'm ready.
So, to forfeit the firearm that was used during this offense, for the defendant to have no weapons, firearms, or replicas, for the defendant to complete the family violence intervention program, and for that to be completed within the first 18 months of probation. For the defendant to stay away from the incident location. It's my understanding that the victim no longer lives there. However, we're still asking for him to stay away from the incident location. For the defendant to have no violent contact with the victim, and for there to be a Fourth Amendment waiver. We do understand in this case that the defendant is asking to be sentenced under the First Offender Act, which you have no objection to, and the state will ask for a 3-year bid date.
Got it.
One thing, I missed the whole stay away from the location because that is not either one of that's his sister's house and he wants to be able to go visit his sister.
I'm not going to impose it.
Okay.
If Ms., is it Willis or Williams?
Yes, sir.
Your cousin, what's her last name?
William.
Williams. If Ms. Williams is okay with nonviolent contact, then he'll need to stay away from any particular place. So I understand the request, but don't worry about it. Okay. Anything else, Ms. Smith? All right, thank you.
Your Honor,
You're here for, all right, yeah, we do have 2 pleas. She's loading us up. We have Ms. Jackson. Good morning, Ms. Jackson. I haven't seen you in forever.
Good morning. How are you, Your Honor?
Oh, I'm better now that we're together.
All right.
Do you have any criminal history information on Mr. Brightwell?
Okay. There are no prior adult arrests on file, Your Honor. Nothing in addition.
All right, thank you so much. Ms. Rios.
Yes, Your Honor. Mr. Brightwell is 22 years old. He has two children, a 4- and 1-year-old that he provides the majority of the caretaking for. He is looking for a job. He does do part-time work through temp agencies, but he hasn't been able to get placement as right lately. So he's just caring for his children. He did graduate high school. I just ask that you accept the plea as negotiated and sentence him under first offender with a 3-year behavioral incentive date. I'm also asking that you waive the probation fees for the first 3 months since he's not working and caring for his 2 young children.
All right, Mr. Brightwell, your 2 kids, do they live with you?
Yes, sir.
Who is in your household?
Carter and Casey and her.
That's one of your kids back there in the back?
Yes.
Okay, and the young lady who's holding your kid is,
One of us, I'm sorry.
that's your mother?
My sister.
Your sister?
Almost.
Oh, there are all sorts of people here.
Yeah.
Is one of them the mother of the little girl?
Right there.
All right, got it. And you and she live together with your daughter?
Yes.
And who else stays with you?
I got another son. I got a 4-year-old. He at school right now.
He's at school? Great. So it's an apartment that you guys have?
Yes, ma'am.
How do you-
Yes, sir. Yes, sir.
How do you pay for the apartment?
I was working. I saved up a little money. When I do work, I save up money to pay. I plan ahead.
Okay, you planned ahead.
Sorry.
And does your child's mom work outside the home or is she taking care of the kid?
My other child, mom,
No, the young lady right here.
I take care of too. I'm sorry. Take care.
It's okay.
You don't have to apologize. We're good here. No one's gonna grab you.
My bad.
So you're the one person who works in the household. Got it. Okay, you need to answer out loud though. So,
Yes, sir.
okay, all right. Do you have anything you want to add to what we've been talking about?
You can tell him no if you don't.
No, sir.
Okay, I got to give you a chance in case you wanted to say something, but you don't have to say anything. I'm going to ask you a few more questions. You want to be sentenced as a first offender, is that right?
Yes, sir.
Do you understand that if you're sentenced as a first offender, this is not a conviction? So when you leave here today, you don't have to check a box on any application saying I'm a felon or anything like that. And if you successfully complete your sentence, you can get this all removed from your record. Do you understand that?
Yes, sir.
That's the good part of first offender. There's a risk though, if you do something like this or get in trouble for any reason, while you're under this sentence, while you're on this sentence, not only would you have new charges, but you could come back here and if the state was able to convince me that you did this new thing, I could resentence you in this case. No trial. You've already said I'm pleading. And I understand it's an offered plea, but that's still a plea. And here it would be up to 25 years. So if you're pretty sure something like this isn't going to happen again, first offender makes a lot of sense. But if you're not so sure that you're going to stay out of trouble for whatever reason, then first offender can be messy. Because if we're together again in a year, you got arrested for something, especially something involving a gun, because you cannot have a gun while you're under this sentence, then I'm probably going to do something with your first offender sentence. And it'll mean you're away from your kids and their moms and all that. Do you feel like you understand the risk and the benefit of first offender?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay. And it's an offered plea, and that's because Ms. Rios, Mr. Brightwell is saying he wasn't there, or there wasn't a gun, or he didn't hit her with the gun.
The involvement with the gun. There was altercation, but he didn't hit her.
He was upset about this posting of things, and they argued he's saying no gun.
Yes.
Got it. Okay. Mr. Brightwell, I'll accept it as an offered plea. That is when a defendant says, hey, I want to work this case out, but it didn't happen the way the state said. Does that describe your situation?
Yes, sir.
Okay. I find there's a factual basis for your plea. If Ms. Williams came in here and looked at a jury and said he had a gun and he hit me and made my ear bleed, they might believe her. I don't know if they'll believe her or not, but you didn't want to take that chance. I also find that your plea is knowing and voluntary. Knowing means you've understood everything we've been talking about. Any questions?
No, sir.
Voluntary means no one forced you to enter the plea. Do you agree with that?
No, sir. I mean, yes, sir.
You agree? Okay, good. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Brightwell, can we electronically put your name on the, sign your name to the indictment?
Yes, sir.
We'll do that. I'm going to follow the recommendation and I'll sentence you on count 1 to 5 years. Those years will be probated. Count 2 has to be 5 years and has to run consecutive. I will suspend those. Special conditions of probation. Number 1, no violent contact with Akira Williams, your cousin. Number 2, you're going to need to complete an anger management course, not family violence intervention program. I don't think that's quite the right fit here. It'll be anger management. And you will have a Fourth Amendment waiver while you're on probation. And finally, you'll forfeit the gun. Was a gun seized when you were arrested? When you were arrested, did the police take a gun from you?
They came to my house.
Okay, and they didn't,
No gun.
no guns? Okay, it's okay. If a gun was seized, you're forfeiting that. I'm setting a behavioral incentive date of December 17th of 2028, which is 3 years from now. If you have done well on probation by then, they can close the case out. If you haven't done well, then we'll press on. And I will waive your probation supervision fees for the first 4 months.
The last name for the victim in the case is Willis, not William.
Okay. Oh, there, the family's clearing it up. It is Willis. It's what Ms. Smith has been saying again and again. Okay. I should listen to her. In the indictment, it says Williams. I thought that's what Mr. Brightwell was saying. But the sentence will say that you will have no violent contact with Ms. Willis, Willis. And I'm waiving those probation reporting fees, supervision fees for the first 4 months. I think that's it. Anything else, Ms. Smith? All right. Anything else, Ms. Rios?
No, Your Honor, thank you.
All right, Mr. Brightwell, I gotta go. You're gonna need to talk with Ms. Simpson. She's with probation. She's not your probation officer, but she's gonna give you reporting instructions. Don't miss your report date, because if you do, they bring me a warrant, and boy, you started off the wrong way. Okay?
Yes, sir.
Any questions about anything?
No, sir.
All right, I gotta go swear in these new lawyers. Investigator Sajak, I'm halfway through. First one about that officer, good to go. But when I come back out, I'll swear you in and we'll get both of them signed. I don't see Ms. Gordon. Is she working her way down here?
She had to run to the schwall.
Okay, good. I mean, I just want them, I'm not forgetting the competency docket, please. We've got until noon to do that. And I know we've got other pleas we can take. So during the next few minutes, think positive thoughts about these new lawyers. Bug Ms. Smith if you got cases with her. And I'll be back. And I'll mute this. Boom.
I'll be back.
You'll be here at 1? Okay. It'll be 1-ish, so try to be as close to 1 as you can, but if we start at 1:10, don't hold it against me.
Oh.
All right. Ms. Willingham stood up. What are we, did Ms. Cabrera make it here yet? Nope. Okay.
For your shipment?
That's a double yes. Okay. Is that someone in custody?
Yes. One of our add-ons.
Oh, it's the add-on. It's right here. Okay. Got it. Yes to Shipman. And Ms. Gordon is here. Are both your clients up
Yes.
here? Okay. And you've talked to them? Ms. Rivers, you ready?
Yes, I am.
Great. All right, this is position 1 on our add-on calendar, State versus Renard Shipman. Good morning, sir.
Good morning, sir.
How are you doing?
Doing okay, sir?
Good. Mr. Shipman is in court with his lawyer, Ms. Wood. Ms. Willingham is handling things for the state. And Mr. Shipman, Ms. Wood tells me that you are prepared to enter a plea in your case. Is that right?
Yes, sir.
Ms. Willingham will put you under oath, ask you questions about you and your case. You need to provide truthful answers. You also need to let me know if at any point you have a question or you want to speak privately with your lawyer. Will you do that?
Yes.
All right. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Renard D'Amico Shipman.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
46-year-old and I have a GED.
You said 46
Yes, sir.
and you have a GED.
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges and to plead not guilty or remain, and if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of the proceeding?
I am.
Have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment?
So wait.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Mr. Shipman, do you understand you are entering a guilty plea to the following offense? Aggravated assault, which has a minimum of 3 years. Aggravated assault family violence, which has a minimum of 3 years and a maximum of 20.
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 3 years probation, no violent contact with the victim. You would be required to complete family violence intervention program, complete 60 hours of community service, and you are required to seek and maintain gainful employment.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum sentence on this charge?
Yes, ma'am.
Do you understand that if you do not accept the court's sentence, you may withdraw your plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Are you on probation or parole for anything anywhere?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced under pursuant to First Offender Act?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of aggravated assault in indictment 25 SC 006171?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand? Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on September 12th, 2025, Officer Feelings was dispatched to 1700 Stanton Road, apartment E21. Upon arrival, officer spoke with the victim, Miss Elbert J. Clark. The officer looked around and noticed that things in the apartment looked thrown about, like an altercation did in fact take place. Ms. Clark initially stated twice that nothing happened aside from Mr. Shipman kicking the door down. She advised that things happened before, but not that day. But then after her friend, Mr. Lawrence Stoner, stepped in and advised that she wasn't going to stick up for Mr. Shipman. That's when Ms. Clark began to report what happened. She stated that the suspect, Renard Shipman, kicked the door down to the apartment that they shared together, chased Ms. Clark into their bedroom, and began to hit Ms. Clark with a closed-handed fist numerous times to her face and choked her until she felt that she could not breathe. Ms. Clark advised that her friend, Mr. Lawrence, witnessed the incident and called 911. Ms. Clark advised that Mr. Shipman kept attacking her until the police got on scene. The officer did not see any bruising or markings on the suspect or the victim. The officer transported Mr. Shipman to Fulton County Jail, and Mr. Stoner verified that Mr. Shipman did attack Ms. Clark. Your Honor, I've had an opportunity to speak with Ms. Clark multiple times. We spoke before this was set for plea and arraignment. At that time, she was leaning towards wanting probation for the defendant. But at that time, she was hesitant on whether she wanted contact. So she asked that we hold off. Last night, I got a call after hours that she really wanted us to go ahead and try and resolve the case. It is my understanding that Mr. Shipman's mother has passed away. And Ms. Clark at that time emphasized that she did want contact. As Your Honor knows, I typically express my concerns about that. But Ms. Clark said that she really did want to be able to have contact, and I know that she was going to contact him. So I also did not want to set the defendant up for failure by imposing a no contact.
Okay, got it. Thank you.
And that concludes the state's portion.
Appreciate it. Ms. Jackson, criminal history information on Mr. Shipman, please.
There are 18 cycles. The last arrest was March the 5th, 2016. And that was with the City of Atlanta Police Department for a parole violation. There are prior felony convictions, one in 2006 out of Bullock County, Georgia, for burglary. And there was one in 2002 out of Statesboro, Georgia, for burglary. And there are misdemeanor convictions, one in 2013 out of Rockdale County for forgery in the 4th degree, one in 2003 out of Bullock County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you. Mr. Shipman, what's your connection to Bullock County?
That's where I'm from, born and raised.
Okay, that's a good connection to have. Ms. Wood?
Thank you, Judge. Mr. Shipman is 46 years old. As you heard, he does have a GED. He was last employed at the Juicy Crab. He does have some health issues, so I'm not sure he's attempting to get on disability, but as of now, he says he thinks he can still work, so he will be looking for a job once he's released. He's been in 95 days. Judge, we spoke with the victim as well, and we're told the same. So his mother did just pass away, so we appreciate Ms. Willingham getting with us to get this taken care of as soon as possible so that he can get out and be with the family. And we would just ask that you accept the state's recommendation.
Mr. Shipman, how would you describe your connection to Ms. Clark? And I don't mean adjectives like it was rocky or it was passionate, but are you boyfriend, girlfriend? Do you have kids together? Are you roommates?
Boyfriend, girlfriend.
Boyfriend, girlfriend. How long have you known Ms. Clark?
4.5 years.
Okay. Do you have kids?
No, sir.
And are you and Ms. Clark planning on re-exploring having a relationship?
Yes, sir.
Okay. Has she been in touch with you while you've been in jail?
Yes, sir.
Your mom would have been back down in Bullock County? Is that where you'd go for a memorial service?
Yes, sir.
Okay. I'm sorry for your loss. Did your mom know Ms. Clark?
They talked 2 weeks before she passed.
Okay, but Ms. Clark was enough of your life that your family knew of her.
Yes, sir.
Does she have kids?
No, sir.
And you think you're going to be able to work, but you also may be exploring whether you can get disability.
Well, I almost died 2 years ago because I have an enlarged heart, and I had 3 heart attacks in the past, and everything was shut down. Long story short, so I tried to when I came out, I tried to apply for disability in the SSI. They turned me down, so I have a lawyer on it now for me.
How many heart attacks do you have to get disability?
I don't know.
Wow. Okay. We'll take care of yourself on that front, but you also need to watch it out with Ms. Clark. Do you have any questions about anything we discussed?
No, sir.
Anything you want to add?
I just thank you guys for hurry up and getting me in here.
Okay. Well, the two lawyers seems like they collaborated well on this. Mr. Shipman, I find there's a factual basis for your plea, and also that your plea is knowing and voluntary. Knowing means you've understood what we talked about. You told me you had no questions. And voluntary just means no one's forcing you to enter this plea. You agree with that?
Yes.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
And Mr. Shipman, can we sign your name to the indictment for your guilty plea?
Sir?
Can we electronically sign your name to the indictment?
Yes, sir.
We'll do that. Mr. Shipman, I'm going to sentence you on count 1, the only count, to 3 years to serve 3 months with the balance probated. Special condition of probation number 1 is that you have no violent contact with Ms. Clark. You can be around her, but if you get arrested for anything related to pushing her, punching her, shoving her, not only is that new charges, but we'll be done with probation. You'll need to figure out how to spend time with someone else after you get out of prison.
Yes, sir.
Number 2, you're going to complete the Family Violence Intervention Program. That's a series of classes, not just one. You'll need to do 60 hours of community service. Let me take one step back. You'll need to enroll in that Family Violence Intervention Program within the first 4 months of being released. So don't wait around to do it. You have 5 months to do the 60 hours of community service. So you need to take care of those in the first 5 months of your probation. I'm going to have you submit to a drug and alcohol abuse evaluation. All that means is someone who knows a whole lot about health and well-being is going to talk to you about what you put in your body. And if that person recommends any treatment, that treatment is part of your probation. So if that person said, you need to go to AA meetings or whatever they recommend, that's part of your probation.
Yes.
And in terms of working, I think you want to work, you need to work if you can work in terms of your health. So I'm not going to put in a requirement. Just know that we want you to be safe. And so if you qualify for disability, great. If you don't, you're going to need to figure out a legitimate way to make ends meet. I will waive your probation supervision fees for the first 2 months when you get out while you're looking for work, trying to figure things out. Ms. Willingham, anything else in connection with Mr. Shipman?
Nothing further, Your Honor.
Ms. Wood?
No, Judge, thank you.
You're welcome. Mr. Shipman, when you get out, what county will you be living in?
Fulton County.
Fulton County? All right. Ms. Simpson's going to come back and talk to you about addresses and the day you need to report for probation. You been on probation before? It would have been a long time ago if you were. Okay, but make sure you report that first day to their office, which is real near here, okay?
Yes, sir.
All right, good luck.
Okay. All right, good luck.
Ju-
Everyone's so festive today.
It's that time of year. And you're wearing, well, is there green on that? Is red and some green? There's green, so you got the festive colors going on.
Are you colorblind?
I'm not, it's just, it looks black and red. I'm not color, my kid is colorblind. I'm not. Not that there's an issue. Do we have any other McBurney, please?
Yes. Mr. Ross.
Okay. Yeah, I don't think I've met a female who's, it runs, part of my grandfather was and Calvin is, everything looks brown to him. Other than the Packers uniform, you can see yellow.
That's so cool. What can you not see?
Yes, ma'am, if we don't see you, have a good holiday break. You taking any time off?
I am. My last day's Thursday.
Ooh, you are coming back though?
I'm coming back this time.
Okay. Yeah, because you pulled that stunt before. It didn't go well, remember that.
It did not.
Yeah, okay.
Jasmine, thank you.
Ms. Nelson, could you reach out to Ms. Cabrera, please, and see if you can get an update for an ETA for her, please?
Yes, I will.
And I'll check my teams. Okay. Let me get the calendar out. You're Calvin Ross.
Yes, sir.
Excellent. All right, this is position 15 on our final plea calendar, 25 SC 003 514, State versus Calvin Ross. He is in court with Ms. Wood. Ms. Smith is handling this for the state. Mr. Ross, you've now watched a plea or two, so you know what's going to happen. You'll be under oath. You'll be answering a bunch of questions, and I need you to let me know if you have any questions, all right?
Yes, Your Honor.
Okay, Ms. Smith?
Yes, Your Honor. Before I start, I just wanted to let you know that count one will be reduced. It'll still be a felony, it's not a misdemeanor, but just wanted to let you know.
To?
That'll be reduced to 16-1330B, purchase, possession, manufacturing, or sale of controlled substance or marijuana.
Okay, 16-30
16-13.
13-30 D as in Delta.
B as in boy.
B as in boy. All right. B as in Braniff. Okay,
All right.
got it.
Mr. Ross, may you raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Calvin Ross.
At this time, are you taking or under the influence of any alcohol, drugs, or medication?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
I got my GED and I'm 37 years old.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
And do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of this indictment and any and all defects in the indictment?
So waived.
Mr. Ross, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
This is the case with the search of the house. I'm remembering it now. It's like, hey, there was a suppression motion here. Okay, we keep going.
Mr. Ross, do you understand that you are entering a guilty plea to the following offenses? Count one, purchase, possession, manufacturing, distribution, or sale of a controlled substance or marijuana. And count two, possession of drug-related objects.
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years to serve 1 suspended, balance probated?
Yes.
Do you also understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked as a result of you entering into this guilty plea?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to this felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering into this guilty plea?
Yes.
Mr. Ross, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment 25 SC 003514, how do you plead to count 1, purchase, possession, manufacturing, distributing, or the sale of a controlled substance or marijuana, and count 2, possession of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that that discretionary appeal must be completed within 30 days of today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
Thank you. Your Honor, if this case were to go to trial, the state would show that on July 24th, 2024, officers Jay White and Moss with the South Fulton Police Department responded to 7876 Wortham Circle in Fulton County in reference to an illegal narcotics possession in a residence where people were squatting. Upon arrival, a search of the residence revealed suspected marijuana, cocaine, digital scales, and a gun. In one of the bedrooms where the suspected marijuana and cocaine was found, there was mail, and this was found in the backpack that was in the closet. In that backpack also was mail belonging to Mr. Calvin Ross. Mr. Ross was not on the scene at that time, but was later arrested and transported to the jail. GBI later confirmed that the substance found in the backpack was 6.1 grams of fentanyl, and it tested positive for fentanyl. And those are the facts of the case, Your Honor. Regarding the negotiated plea between the state and the defense for count one, we've agreed to 7 years to serve one, with that 1 year in custody to be suspended and with the balance to be probated. And for count two, 12 months to run concurrent to count one. Regarding special conditions, the state is asking for a drug and alcohol evaluation treatment if necessary, a Fourth Amendment waiver for the defendant to complete 70 hours of community service, for the defendant to be gainfully employed and show proof every 90 days, and for the defendant to pay a $3,000 fine. And that's all from the state, Your Honor.
Thank you. Ms. Jackson, any criminal history for Mr. Ross?
There are 8 cycles. The last arrest was November the 15th, 2023, out of DeKalb County for criminal damage to property in the 2nd degree. There was no disposition for that arrest. He does have 1 misdemeanor conviction out of Tennessee. It was in 2014 for a DUI. Nothing in addition, Your Honor.
Thank you. Is this a first offender plea?
Yes, Judge, because I'm almost positive that criminal damage was dismissed. The GCIC just didn't have, so usually it marks if it was first offender, he believes it was dismissed. So we're asking for first offender treatment and a behavioral incentive date. Judge, he's 37 years old. He's originally from Tennessee. He's been in the Atlanta area for 12 years. He has 2 children, ages 2 and 12. He does have a GED. Judge, he works as a long haul truck driver. I've explained to him that it is imperative that he make sure he lets probation know when he needs to be wherever. Because I have had clients who have not done that, and then it results in a warrant.
Right.
So we've gone over that. I believe he's a good candidate for first offender as well, Judge, since he's 37 and has not had any serious violations of the law. So we would just ask that you accept the state's recommendation in this case.
And do you want it as first offender, the Title 48, wherever it is, or the drug one?
Right, the 1613-2, the conditional discharge one.
Conditional
Thank you, Judge.
discharge.
I forgot, so thank you.
No problem. All right, I'll explain what that means, Mr. Ross. We're not speaking in code. Do you have any questions about anything we discussed?
No, Your Honor.
Okay, anything you want to add? I know a little bit about it because we had a suppression hearing, and I know this was your cousin's place pretty much through and through. You helped him get it because you had better credit, but he lived there. Problem is, some of your stuff was found there, kind of interconnected with the stuff that shouldn't have been there.
Yes, sir.
Sounds like that's it. You in touch with your cousin?
I haven't spoken to him in about a month.
What happened?
I have no idea.
He dropped off the map, or?
He kind of just dropped off the map. I
Okay.
don't know if he's in jail or I don't know.
Well, I hope he's all right, but maybe it's better that you and he are spending time apart. Because here you are, because what was in his house. Tell me about the trucker work you do. And I ask, because I'm always curious, but probation and you driving to Minnesota all the time don't get along real well.
Well, my job is kind of I work when I want, I go where I want. So if my PO needs me to be somewhere at a certain time, I can arrange that with my dispatch.
Okay, or it sounds like you'd be able to let probation know, hey, I just got a contract to go to Oregon
Yes,
to,
sir.
to pick something up or deliver something, and you wouldn't be calling them while you were in Tennessee saying, I'm on the road. You'd be able to say, I'd like to leave the state on these dates to deliver this.
Yes, sir.
Okay, that's how it would need to work. You can drive to your heart's content in Georgia, but if you get something long haul, that's something you need to clear in advance with probation. It doesn't work to call them from St. Louis to say, oh, by the way, I already left Georgia.
Understood.
Okay, good. Well, Mr. Ross, I find there's a factual basis for your plea. Like I said, I'm pretty familiar with how it went down. And that I find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one has coerced you into making this plea. Do you agree with that?
Yes, Your Honor.
Yes? Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And is it all right, Mr. Ross, if we electronically sign your name to the indictment?
Yes, Your Honor.
Your lawyer has asked that you be sentenced under the conditional discharge statute, which is just like first offender. What that means is that while you are under sentence, you are not a convicted anything. And so if for work, for whatever you're doing, someone says, hey, what's your criminal history? The answer is, I don't have a felony conviction. You don't have to check that box. Assuming you don't mess up while you are on probation, this can all be wiped off your record. And so you remain with no felony conviction as long as things are going well on probation. That's the upside. The downside is if 6 months from now, your book bag with fentanyl in it is found in someone's place and you get prosecuted for that, all this first offender or conditional discharge can go away. The prosecution can ask me to resentence you, which I probably would if in the next year or so you're getting in trouble for something like this. Now, if you get pulled over because you ran a stop sign, then you have a ticket. We're not going to have to talk about that. But if it's hardcore criminal stuff, then you could lose your conditional discharge and without a trial, get resentenced pretty high up in the range that you're looking at. Does that make sense?
Yes, sir, it does.
Understanding that, do you want to be sentenced pursuant to conditional discharge?
Yes, Your Honor.
Okay, I'll do that. And what I'm going to do on count one is sentence you to 6 years. That will be probated. Count two will be 12 months. That'll be probated. They'll run concurrently with each other. Special condition of probation number one is stay away from that address on Rotham Circle. Number two is that you complete 70 hours of community service, and you need to do that in the first 6 months of your probation.
Yes, sir.
You're going to pay a $3,000 fine. You pay that as you're able. If you're not earning 1 month, you don't pay much. But if you're earning, some of that needs to go to that fine. And you pay it through probation. You don't need to worry about where do I go. They'll collect it for you and they get it to the state or the county, wherever it ends up.
Yes, sir.
You will have a Fourth Amendment waiver, meaning your probation officer can search you or your truck or whatever whenever the probation officer wants to do that. And you're going to submit to a drug and alcohol abuse evaluation. You need to do that during the first month of your probation. And if that conversation prompts an expert to say, you know what, I think Mr. Ross would benefit from some treatment, then that treatment is part of your probation. But if there's no issue here, then there's no treatment. That's how that'll work. I will set a behavioral incentive date of December 17th, 2028. That's 3 years from today. If you have done a spot-on job with probation, no issues, then they can say, can we just close this out? Because this guy's not, we're wasting our time supervising him. And I'll likely sign it and you'll be done.
Thank you, Your Honor.
Well, you can thank me by not getting in trouble. Just drive those trucks and do whatever else you do. Ms. Smith, anything else for the state?
No, Your Honor.
Ms. Wood?
No, Judge, thank you.
All right, Mr. Ross, don't run out of the room. You need to talk with Ms. Simpson, who's in green there. She is going to give you reporting instructions. What county do you live in?
Cobb.
Cobb. Okay, she's going to give you instructions as to where to report in Cobb. And she'll probably step outside with you, but just don't leave until she's given you that info.
Okay.
All right, that's it.
Thank you, Judge.
You're welcome.
That's, the USB drive.
Okay.
You can have it for your fix. You're welcome. So, happy holidays.
Mr. Royals.
Yes, sir.
This is a big number, 39 in like an hour. What were these grand jurors doing? They just, you'd slide it in and this was the true bill arm?
Sir, progress is not a slow process.
Okay, yesterday, there was like a third of this and you came later.
I wasn't here yesterday.
Well, that's right. You were invisible yesterday.
Yes, indeed.
You were. I forgot the stealth outfit. There are also different types of indictments. The indictments yesterday were a hot mess, especially that special event out at the jail. All right, I'll keep this. I'll sign here. 16th. Are you the lucky winner today? It's great to see you.
Thank you.
Got it. Oops, let me give you, you need one of those. All right. Can we do one of the Sellers Gordon cases?
Yes, sir.
Because I think Ms. Cabrera needs to talk with Ms. Smith a little bit.
Yes, well.
I don't know. You just got here and Ms. Smith's like, really? Those are pleas?
Yeah.
Her eyes got real wide.
Things that we need to take care of. Ms. Farian, but we can't handle that today. That's, we have to meet with the state, I think it may be set for one day next week, and so I was gonna be asking if we preserve our final plea rights. Then we will proper.
Okay. So if nothing resolves by the 7th, then you and she will be here on the 7th for the trial calendar. Got it. So whatever you're hoping to do, you would take care of before the 7th.
Sherry has a recommendation. I shared the recommendation with her, but the state did ask about a proper.
For a conversation.
And
Got
she
it.
agreed.
Okay.
And they said that one day next week might work.
This week is.
So one day next week might work. I just don't know the dates.
Okay.
And then McLester is off of your calendar, but that is a plea whenever your honor is ready.
Yes. And is Ms. McClester here?
Yes,
Okay.
I've already spoken with her.
Great.
I have to go in the back and speak to Baker, but I don't know about that movement. And Miss Harrington.
Yeah, I don't see her anywhere.
She should be on bond.
Right. But she should be here.
Was her mother here this morning?
No one answered when I called her name. So you. She's gone. Maybe we can get someone on to hear about her situation.
I have a phone number. I'll call.
Okay.
Find out to see if we can get her. But I don't anticipate that being a plea to 10 years. She's on bond and part of the offer includes 10 years.
Right. And so I was surprised. The notes I got from Ms. Nelson said plea and Ms. Smith's eyes got really like, woohoo.
No, I sent her a message that I had pleas, yes.
Okay.
But yeah, so that's not a plea. And then Mr. Baker is in the back. I need to.
You got to talk with him. All right. So I'm going to take a plea on one of the competency docket cases while you are doing that stuff, trying to get Ms. Harrigan or mom connected.
I'll make that phone call. Dishes.
Yeah, Ms. Faria, you are good to go. You are going to have a conversation with some folks either this week or next week. Important conversation. Make sure you follow Ms. Cabrera's lead on that. And then I think that's going to help Ms. Cabrera sort your case out. I will see you at the latest on January 7th. That's the trial calendar, but it may be that you sort things out before then. Okay, any questions? You have a way to contact Ms. Cabrera? Yes, sir. Good, thanks for your patience.
Did you want to do first?
So we've got Wilson and then it starts with D.
Dawkins.
Yeah. Who do you want to do?
Doesn't matter.
Well, we'll go reverse alphabetical order. Let's do Wilson. He was always last in line in school. He can go first.
So nice of you.
Let's find that. There's Wilson. Dawkins. Okay. Ms. Jackson, you are not on the hook for these criminal histories. Your colleague is here in court, and we'll do that. But I do need Ms. Rivers, your powerful fingers to take down these two pleas, please.
Thank you.
Deputy Gordon, can you adjust the monitor so we can get Mr. Dawkins? He's tall. There we go.
This is Mr. Wilson, Judge.
I'm sorry. All right, we did reverse alphabetical order. Mr. Wilson, which is position 4. Good morning, Mr. Wilson.
How you doing, sir?
I'm okay. We're going to get on the record. Your case is 24 SC 003269. I'm Judge McBurney. We've not met before, but I work with Judge Ingram, and she's had your case actually from when it was very first indicted, and then it got transferred to a different place. Ms. Gordon's been your lawyer. Ms. Sellers is the prosecutor, and I'm going to be part of the conversation about whether you want to enter a plea in your case. And Ms. Gordon told me that you are interested in working your case out. Is that right?
Yes, sir.
Okay, great. Ms. Sellers is going to ask you some questions about you and about your case, and you need to answer them as best you can. If you're confused by any of the questions, she uses words you don't understand or they just don't make sense, will you let me know?
Yes, sir.
Great. And if at any point you want to talk with Ms. Gordon privately, let me know and we can make that happen.
All right.
All right. You ready to go?
Yes, sir.
Okay. Ms. Sellers?
Thank you, Judge. Please raise your right hand.
Oh, I'm sorry. One more thing. Ms. Nelson, Ms. Green is here in court and is going to be taking care of the final dispositions for the 2 competency docket cases. So it's just Ms. Rivers and the judge from Team McBurney who need to take care of things here. Sorry. Back to swearing in.
Thank you, Judge. Please raise your right hand. Do you swear or affirm that the statements that you will provide to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may place your hand down. Please state your true and correct legal name.
Roger Warren Deshaun Wilson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have
Hey,
not?
Deborah Preston and Benadryl.
Okay.
Mr. Wilson, make sure you may know the answer before she finishes the question, but just let her finish the question before you answer. It's hard for the court reporter to write things down when people are talking over each other.
Yes, sir.
Okay, thank you.
So I'll just repeat that question. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I take Deborah Preston and Benadryl.
Okay. And those medications that you have been given, are those prescribed by a doctor?
Yes, ma'am.
Okay. And having taken those medications, do they affect your ability to understand the proceedings today?
No, ma'am.
How old are you, sir?
32.
And how far have you gone in school?
Graduated
Graduated college, high school?
May 14, 2012.
What high school?
Tri-City.
Good for you.
Thank you.
You're welcome.
And you are able to read, write, and understand the English language?
To the best of my ability.
So what does
Yes,
that mean
ma'am.
to, yes. Okay. Do you understand that you are being charged with the following offenses? False imprisonment, count 1, count 2 and 3, willful obstruction of law enforcement officers, and count 4, battery. Do you understand these charges that are before the court today?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
And this includes any potential defenses.
What they defense? Oh, yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No, ma'am.
And are you satisfied with your attorney's services today?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes.
And do you waive any and all defects in the indictment?
Yes.
Mr. Wilson, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading to today?
Yes, ma'am.
And you understand that for count one, the charge of false imprisonment, that carries a sentence of 1 to 10 years. And count 2 and 3, willful obstruction of law enforcement officers carries a sentence of 1 to 5 years in custody on each count. And count 4, battery, carries a sentence of up to 12 months in custody.
Yes, ma'am.
You understand that this is a negotiated plea of guilty, which means that the state is recommending the following sentence to the court: 5 years to serve 2 years, reduced to the time that you have already served. And the balance of 3 years is to serve on probation. And a special condition of probation is to remain compliant with the Grady Act team and to apply to the PAD program. Do you understand this negotiated sentence that is being recommended to the court?
Yes, ma'am.
Okay. Do you understand that the court does not have to accept this negotiated recommendation and can sentence you to the entire balance available to the court?
Yes, ma'am.
And do you understand that if the court enters a sentence that you do not agree with, you have the right to withdraw your guilty plea?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
So you say you run it past me
Absolutely.
again?
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
So if you got arrested and charged with another crime here or in a different court or in a federal court, they would be able to look at this conviction and that could make your sentence in that case worse because you have this prior conviction. Oh, yeah, ma'am.
And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
And do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Say it again.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
So that just means that when we enter a plea of guilty, we're not going to trial. The defense that we might present if trial. Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And I will go through a list of those rights. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand these rights that you are giving up today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
And it is your decision to waive these rights and enter a guilty plea because you are in fact guilty.
Yes, ma'am.
How do you plead to the charges of false imprisonment, willful obstruction of law enforcement, counts 2 and 3, and battery in indictment 24 SC 003269?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
And if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. And this discretionary appeal procedure is outlined in OCGA 5635.
That means, okay.
Just means if you think that there was something about plea read today, you can.
And bring it before them. Oh, yes, ma'am.
If you would like to appeal this guilty plea conviction, then you have 30 days from today to follow that procedure. And do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
At this time, Your Honor, I will go on the record with the facts in this case. If this case were to go to trial, the state would prove the following facts beyond a reasonable doubt: that on April 2nd, 2024, at 58 Edgewood Avenue in Atlanta, Georgia, in Fulton County, Georgia State University student, Jontavin Strong, Jontavynn, reported that while walking from the Rialto at 8040 Forsyth Street in Atlanta, she noticed a Black male, later identified as Mr. Olajuwon Wilson, walking behind her. When Ms. Strong was at 58 Edgewood Avenue, she advised that Mr. Wilson stopped her, grabbed her arm, and pushed her to the ground. Ms. Strong was cut on her right index finger near the palm of her hand when she was pulled to the ground. And she additionally advised that she was in fear for her life and urinated herself when Mr. Wilson threw her to the ground. Mr. Wilson stated to her, "You're too pretty, let me talk to you," and attempted to snatch her phone. Mr. Wilson would not let her stand up and also sat beside her. Ms. Strong stated that there were 2 witnesses, an individual on a bike and a woman walking by, who tried to reason with Mr. Wilson to let her go. Ms. Strong stated that when Mr. Wilson only got up when Sergeant Mathis walked toward them. Sergeant Mathis then reported the incident via radio. And Mr. Wilson would not identify himself, so then he was taken into custody and they were able to identify him. Ms. Strong did decline medical attention, but was taken to Georgia State University Police Headquarters for access to first aid kits for her wound. On the same day at approximately 8:17 p.m., Officer Keys and Officer Peters while on patrol, heard over the radio from Sergeant Mathis that a student was assaulted on Edgewood Avenue and Peachtree Center Avenue. As they walked down Edgewood Avenue, the officers saw the Black male immediately run away. when he saw them, so they chased after the individual on foot, and Sergeant Mathis confirmed that this was the individual that the victim stated assaulted her. Officer Peters tackled Mr. Wilson to the ground, and while conducting the search, Wilson then spit on Officer Key's face. Officer Peters restrained Wilson using a pressure point on the back of his neck against the vehicle so he could not spit on the officer again, and placed him in vehicle 427. Wilson was transported to Georgia State University Park Stadium holding cell at 755 Hank Aaron Drive in Atlanta, Georgia. While Wilson got out of the vehicle, he lunged at Officer Peters' face and tried to bite him on his cheek under his eye. Wilson was then pinned to the ground and restrained for officer safety until he stopped lashing out, shouting, "Kill me, N-word, I want you to kill me." Wilson, while inside his holding cell, then ate soap from the soap dispenser, and he was restrained for his safety. He was later transported to Grady Memorial Hospital, where he was additionally combative with staff at that time. And he had to be placed in a spit hood over his head. He was subsequently medically cleared at Grady Hospital and then charged accordingly and arrested. Those are the facts of the case, Your Honor.
All right. So Ms. Strong, as far as you can tell, is a complete stranger to him and
Yes.
just happened to be the one singled out.
Yes, Your Honor.
Got it. What do you have for criminal history?
23 cycles, I got a 2017 robbery, first offender.
First offender. All right, thank you. Ms. Gordon?
Yes, Your Honor, we are asking that the court accept the plea as negotiated today. Mr. Wilson was very ill at the time of this incident, which I think is clear from the facts of the case. He has been in custody now for, I think, 623 days, is what I just saw. Underwent a course of restoration, is now competent. I do believe he is competent and he understands what's going on here today, and he understands the terms of and the consequences of the plea today. We do have him set up with PAD for housing, as well as Grady with intensive case management. So ICM, not ACT.
Okay.
And if all goes smoothly and as planned, he will be released the day after tomorrow on the 18th. PAD is planning to pick him up. So hopefully very, very soon, I should have an email back from Ms. Montero with PAD with the details of the release plan, which I will then email to Judge Ingram and Ms. Green, and Judge Ingram will do the release order.
Excellent. Okay. I'm happy to help if for some reason she's stuck in trial and can't because I'm taking the plea. I'm familiar with these parameters, but start with Ms. Green and she'll find whichever is the right judge to do that.
Thank you.
Okay. Well, I appreciate everyone's work to identify some options for Mr. Wilson. So Mr. Wilson's place to stay will be housing provided by PAD.
Yes.
Got it. Mr. Wilson, do you feel like you've understood what we've been talking about?
Yes, sir.
Do you have any questions about things?
No, sir. A couple questions with Ms. Gordon.
Okay, well, you can talk with her when we're done, unless you want to have her answer those before you and I talk.
Anything you can ask me, I'm cool with that, but I just had a couple questions for Ms. Gordon.
Do you want to talk to me before we finish the plea, or do you want to talk to me after the plea is done? After? Okay.
Yeah.
Okay, great. Then we'll keep going. Mr. Wilson, do you have family in the Atlanta area?
My mama recently moved back to Chicago with my sister and my auntie. My daddy from Tennessee, but I really not really good with my parents like that, so I really spent most of my time in the neighborhood.
Okay. Well, Ms. Gordon and her team have found you some housing. I'm going to need you to try to stay there. That's a great opportunity for you. I know life is complicated and you may feel certain things that make you want to wander, but this is a safe and stable place for you to be. So I hope you take advantage of it, at least for a little while. I find there's a factual basis for your plea. What happened in April of last year was real scary for this young lady. My guess is you weren't taking medication at the time and probably weren't even aware of some of the things you were doing or saying, but it was very upsetting for her. And then it was difficult for these officers to try to stabilize the situation. What that says to me is that you need to stay focused on trying to keep up with your medication when you're able, and that's where the Grady team will help. They'll make it available. They can't force you to take any medication, but you know what it's like when you don't take it. And I hope you do take it, because you and I are having a real good conversation. I'm not nervous about having a conversation with you right now, but that's because you took your medication. If you don't do that, folks are going to treat you differently. They're going to be scared of you for all the wrong reasons, but then something like this could happen again, and you've been in jail for a long time. I bet you're ready to get out.
Move forward.
Yeah, move forward. Amen. So I find that there is a factual basis for your plea based on what I heard, and that your plea is what we call knowing, meaning you've understood things, and voluntary, no one's forcing you to enter the plea. Do you agree with that?
Yes, sir.
Okay, then I'll accept it. Ms. Gordon, can someone in Judge Ingram's office sign the indictment on your behalf?
Yes.
And Ms. Sellers?
Yes, Judge.
And Mr. Wilson, is it okay if they use a computer to put your name on the indictment that you just pled to?
Yes, sir.
Okay, I'll make sure that happens. I want to be clear that I'm comfortable taking this plea, Mr. Wilson, because I find that you're competent to stand trial and to take a plea. And I base my finding of competency on the opinions of Dr. Raymond, who evaluated you. And in August of this year, she wrote me a letter and Ms. Gordon a letter assuring us that you were doing a lot better and that you were ready to move forward, to use your words. And so I'm adopting Dr. Raymond's findings as my own, finding that you're competent to have the conversation we just had and to enter this plea. And I'll accept it. I'm going to sentence you on count 1 to 5 years to serve 1 year and 8 months. And you've done a few more days than 1 year and 8 months. Count 2 will be 5 years to serve 1 year and 8 months. Same with count 3. And count 4 will be 12 months to serve. Those are all going to run concurrently, meaning at the same time. So basically, you've served the amount of time that you need to. And on Thursday, day after tomorrow, hopefully you'll be released. PAD will come get you and get you to your housing. There are 3 special conditions of your probation.
Yes.
Number 1, you comply with the Grady ICM team. If they say we need to meet with you on a Tuesday, you come meet with them. If they say you need to go to this counseling session, you go to that counseling session. Number 2, you formally apply to the PAD program. They can't make you do anything, but I'm going to make it a requirement that you at least apply and say, could you help me with housing and with other services? And the last one is that you take all the medication that doctors tell you to take. So I can't force you to do it, but it's a condition of your probation. So if you decide, hey, I'm not taking, I don't remember all the medications you said you're taking, but you've just decided on your own you're not going to take it, that's not consistent with your probation. So you do need to, if you take a medication that makes you feel kind of funky, you should talk to the doctor to see if she can get you a different one. But you don't get to just throw the bottle away and not take it. You all right with that?
I understand.
Good. Any questions about anything I said?
No, sir.
Ms. Gordon, anything else on behalf of Mr. Wilson?
No, Your Honor.
Okay. Ms. Sellers, on behalf of the state?
I don't know if you have to order that he have a mental health officer, probation officer.
Well, I'll request it. I don't think I get to tell DCS what to do, but my request is that Mr. Wilson have a probation officer who's trained to work with folks working through mental health issues. I think that'll help. I think the Grady ICM team is the key one, but your probation officer can help as well. That's a great idea. We don't know where Mr. Wilson's going to be. Is most of PAD's housing in Fulton, or is it sort of a TBD as to where Mr. Wilson would be reporting?
I will put him in the system as homes.
Okay,
Because we had places in different places.
okay. And they may move around.
Exactly, and so once he reports, when they give him an address, he can just provide that address.
Okay. So you'll give Mr. Wilson reporting instructions. So Mr. Wilson, Ms. Simpson works with probation. She's not your probation officer, but she works with them, and she's going to tell you when you need to report to probation. That's a real important meeting. They're going to expect you to show up, and if you don't, they're going to immediately be worrying, here we go again, Wilson's on the run, he's not moving forward. So make sure that you get to that meeting. And if you're having trouble figuring it out, hopefully you've got a way to reach Ms. Gordon and she can give you some suggestions on how to get to the probation office.
Transportation, that's what I need, that's what I wanna know.
I hear you. And Grady ICM may be able to help with that. Pad may be able to help with that. The probation office is about 2 blocks from here. And so you really just need to get to near the courthouse, and the probation office is just, you can walk there from here. Okay? But folks are gonna be wanting to help you get there. After you have your first meeting there, then it's easier. Your probation officer may come to you if you don't have good transportation, but that first meeting's pretty important, okay?
Yes, sir.
All right, thank you. Good luck.
Okay, thank you, Ms.
Thank you.
Gordon. He covered.
He covered the questions you had?
Yeah, I want to ask.
All right, okay. Okay, all right. Good luck, Mr. Wilson.
All right, we've got about 30 minutes and then I have to go and then I'll be back at 1. So you guys can arm wrestle as to who's gonna do what remains. My preference would be to do folks who are on bond. I'm available all afternoon. I have another calendar, so we could weave it in. I don't know what Ms. Sellers and Ms. Gordon, your schedules are, but I don't think we can fit it in before I have to stop.
I can be back at 1 year.
Or does that work? Why don't you be back at 1:15, just so you're waiting less? Okay? Ms. Smith, is the plea we're about to take your case?
Yes.
Okay, and then you have stuff on the 1 o'clock anyway, so you'll be back. All right, Ms. Wood, I'm sorry, we're gonna need to do one of yours, or did you have something in the afternoon?
I have stuff on the afternoon.
Okay, so you're coming back anyway. All right, so let's aim to be back at 1:15, and we will do Mr. Dawkins, and other things like that. But what we're gonna do right now is, if I can find my freestanding piece of paper, Ms. McClester. Are you Ms. McClester? All right, why don't you come on up?
And Ms. Harrington is not answering.
Okay,
It's going straight to voicemail.
all right, well, we'll do a bench warrant, but if she walks in with you in tow, or you walk in with her in
I'll
tow?
see if Keith Adams has her mom, then maybe I can get her through her mom or whatever.
Yeah, his associate was here virtually, and shared the bad news that Mr. Adams had a loss in the family. He's around, but he'll be out of the country the week of the trial calendar.
Okay.
Which isn't for a bunch of weeks. So you and Ms. Harrigan, if you are able to connect with her, can still,
When would the trial calendar week be? I know they called on the 7th, but.
that Monday, the 12th.
Is this? Okay.
All right, so bench warrant for Harrigan for now. Ms. Smith, you'll take care of that?
Yes.
Okay. All right. Yes. Karen with a K. You bet. You like cooking onions in the jury room? It's smelling very oniony. It's like, that's not the holiday smell. It should be like pine or mint. It's like, okay. This is position 2 on our add-on calendar. Ms. McClester, it's 25 SC 005-156. And Ms. McClester is here in court with her lawyer, Ms. Cabrera. Ms. Smith is handling it for the state. Ms. McClester, Ms. Smith's going to put you under oath in just a moment, ask you questions about your case. You answer them truthfully, and we'll go from there. If at any point you need to speak privately with your lawyer, let me know, or if you've got questions, okay?
Yes, sir.
All right. Mr. Akins, I haven't forgotten about you. If we finish this plea in time, you and Ms. Simpson and I are going to talk, okay? You're welcome to stay. I know if you're Lakers, you can move around. Just come back, okay? All right. Let's go.
All right. Ms. McLester, may you raise your right hand? You swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Can you state your true, correct, and legal name for the court?
Yes. Takia Janae McLester.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
I'm 22. I graduated from high school,
Where'd you go to high school?
Tri-Cities.
2 Tri-Cities today. All right. They're doing well with all these graduates.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am, not anymore.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
And do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waive.
Ms. McLester, do you remember being arrested on these charges?
I was already incarcerated when those charges occurred, so I do.
Got you. The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No warrants.
Do you understand that you're entering a guilty plea to the following charges? Count 1, riot and penal institution. 2 counts of willful obstruction of law enforcement officers by use of threats or violence. And count 4, willful obstruction of law enforcement officers.
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 4 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Are you currently on probation or parole?
Yes, I'm on probation.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
She understands that, but it's already been, they've already handled the revocation.
Okay.
Yes.
Mhm.
And that revocation was for this new offense?
Yeah, it is.
Okay, got you. Are you United States?
I'm gonna weigh in because you look tentative here. You cannot be revoked twice for the same thing. So if you already, Ms. McLester, had a hearing where a judge said, "All right, I'm doing X because of this case, the fight in the jail, whatever this was about," then I don't get to revoke a second time. The fact
Okay.
that you're pleading today doesn't change that a judge has already said there are consequences for your probated case because of this.
And probation already.
Yeah,
confirmed
she
that.
already said, yeah. I
Yeah,
remember
right. So we're not gonna re-revoke or anything like that.
Okay.
I'm still gonna give you a sentence in this case. The
Yes.
recommendation is even more probation, but we're then not gonna go back and say, "Oh, we're gonna revoke you again."
Right,
Okay.
okay.
Now, that doesn't mean in 6 months I wouldn't revoke you if you got something new, but that would be something new.
You're right.
Okay.
Ms. McLester, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to this felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading guilty to these charges?
Yes.
Ms. McLester, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea today?
No.
As to indictment number, I should have this, hold on. Hold on, I gotta get my computer. Hold on really quick.
What are you looking for?
The indictment number.
It is 25 SC 005 156.
According to that indictment number, how do you plead to count 1, riot in a penal institution, count 2 and 3, willful obstruction of law enforcement officers by use of threats or violence, and count 4, willful obstruction of law enforcement officers?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that that discretionary appeal must be done within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on July 23rd or June 23rd, 2024, Atlanta City Detention Officer Grant observed inmate Takia McLester charge aggressively toward another inmate, Sakasi Step. Their first name is spelled Sukasha. Thank you. The officer then observed Ms. McLester to begin punching the other inmate in her head with a closed fist. Ms. Stepp, who was the other inmate, returned violence against Ms. McLester and attacked her. The inmates were given orders to stop fighting, but they did not. The defendant, Ms. McLester, was tased and the officers were able to separate them. Officer Grant escorted the defendant in this case to a room and attempted to place handcuffs on the defendant. Ms. McLester resisted being handcuffed by pulling away from Officer Grant and refusing to cooperate. Ms. McLester then threatened Officer Grant by saying, "I don't give a F. H's keep playing with me. Get off me. Get these handcuffs the F off of me or it's up." After Ms. McLester was handcuffed, she removed them by twisting her wrist and manipulating her wrist to slip out of the handcuffs. Ms. McLester was eventually placed back into her cell. The officers then came back into her cell to transport her to the Fulton County Jail. And at that time, Officer Solomon entered Ms. McLester's cell to transport her. And the defendant threatened Officer Solomon by saying, "I don't give a F about no charges. When I get back into this pod, it's up. Y'all H's better get ready. When I see you, Irma, I'm gonna spit on that B." Irma is another detention officer that was at the detention center. Upon exiting the pod, Officer Permy was seated at her desk, and at that time, Ms. McLester started yelling to Officer Permy multiple times to get her attention, but the officer ignored her. The defendant then began aggressively walking toward Officer Permy and threatened her by saying, "B, I'll spit on you. Lame AH. I better not catch you in these streets." Officer Solomon went hands-on with the defendant to direct her against Officer Permy. At the time, she was then charged with the following offenses. And those are the facts of the case. Regarding the sentence for the charges, the state and defense has agreed to, for counts 1 through 3, 1 year of probation, and for count 4, 12 months of probation, for all of those counts to run consecutive for a total of 4 years. regarding the special conditions of probation. The state is asking for 60 hours of community service, for the defendant to be gainfully employed and to show proof every 90 days, and for the defendant to enter and complete an anger management course. And this probation is to be ran concurrent with her current probation that she has for the charge.
Got it.
Verification that happened.
Okay, hold on one second. She came out. I gave it to her. We're good.
That's all from the state, Your Honor.
Got it. Thank you. Ms. Jackson, do you have criminal history information for Ms. McClester?
Yes, Your Honor. There are 7 cycles. The last arrest was November the 12th, 2025 in Fulton County for disorderly conduct and a probation violation. And she appears to have 2 open probation cases. The first one is 24 SC 0022742 for armed robbery. That disposition date was November the 6th, 2024. The term is for 19 years. And the other case appeared to run concurrently with this one is 23 SC 191934 for 2 counts of armed robbery. Same disposition date of November the 6th, 2024, and the term is for 19 years. She still has an outstanding hold pending in the GCIC out of East Point for the disorderly conduct. The date on that warrant was August the 20th, 2025. Nothing in addition.
Thank you. Armed robbery. What was going on, Ms. McClester?
I was with the wrong people at the wrong place at the wrong time.
I see.
And
Yeah.
7 times, I don't know how that worked, but I ain't been incarcerated 7 times. I ain't never been in trouble for real.
Doesn't say you've been incarcerated 6 times. It means you've been arrested, but sometimes you can be released with a ticket. I'm focused on these armed robberies and mostly just, you're only 22. You don't need to go back to jail. You need to be doing other things. And so I hope however we structure, you have moved real fast in not very many years on this planet to have 2 armed robbery convictions where fortunately for you, you had a good lawyer and a judge who was open-minded about things. And so you spent a long time. I got you 348 days in jail. So you spent about a year in jail. For someone who has been legally an adult for only 5 years and maybe emotionally adult for not yet. So that's a lot of time to have been sitting in jail. It's usually young men I see like that. And here you're a young lady. So I hope for your sake, you are heading in a different direction. But I'm going to hear a little bit about you from your lawyer.
Yes, Your Honor. As you mentioned, she is 22 years old. She did graduate high school. She has a son that was born October 5th of this year. Currently, she is working at a hotel where she also is living. So they've handled everything with their probation. What I'm assuming is that they'll go on ahead, run them concurrent. She'll have the same probation officer and be able to do that. She has some concerns about community service and being able to get that done. I explained to her that she could talk to them and see if they had recommendations on where the community service could be done, but that it had to be a nonprofit 501c3 for her to do that. So she understands that she has that, but that was primarily her concern. She just wanted to make sure that those things stayed together. She also completed anger management already within the past year, but I shared with her that maybe as far as probation is concerned, she needs to provide that to probation and they'll determine whether or not that's sufficient to meet their requirement.
Okay, got it. All right, so Ms. McClester, you have a little boy.
Yes.
What's his name?
Mazzari.
How do you spell that?
Messari.
Messari.
Yes,
That's a cool name, Mazzari.
It's
And
a
he's,
biblical name, actually.
is it what?
A biblical name.
Well, it can be cool and biblical, so it's both. Mazzari, and you live at a hotel right now, and you work there?
I do housekeeping.
Housekeeping, okay. Does Mazzari's dad play a role in his life?
Well, he do have his father in his life, but he lived with me and my girlfriend.
Okay, got it. That was someone who was here because you pointed to the wall.
Yeah, yeah.
She didn't leave you. Okay.
Not this time.
So you and your girlfriend and Mazzari are in the hotel. Does your girlfriend work?
Yes.
What does she do?
She work at Five Guys.
Okay. So she's got a job. Your hotel job, is it pretty regular? Like it's.
Yeah, I work every day. Like,
Okay.
well, really 5 days a week. I'm off on the weekends.
Good. Okay. Are you and your girlfriend looking for a non-hotel residence?
Yes, most definitely.
Okay, good. I mean, hopefully you can get an apartment soon if you're both working. That would be
That's
good.
exactly what's going on. We on a 90-day run right now.
Does she have any kids? Mazzari is the one kid in the household. Okay, all right. Well, it's promising that you're both working, because if you save up, you should be able to get your own spot.
My probation officer gave me 90 days.
90 days to find a place?
Like 90 days to. She was asking me how long do I think I'm going to be in that area or that position.
Yeah.
And I told her 30 to 90 days. Because, like I said, I'm on my 90-day run. So.
Okay, good. Well, let's make that happen. Stable housing would be good,
Yes.
especially for Mazzari.
Exactly.
But dad is present in his life and helps out.
And when I can't, like, when I'm struggling, like, when it comes to my room and stuff like that, he's able to go to his father's house. Like,
Okay.
you get what I'm saying?
Got it. Okay. All right. Any questions about anything we discussed?
No.
No? Hopefully the people you were running with and the attitude you were showing when you were in jail is sort of behind you a little bit?
I can say I've came to a lot of self-control. Like, yes, I came a long way with my self-control and my anger.
Good. Okay. Well, hopefully you'll move forward with that as well.
Yeah.
I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood what we've been talking about and no one forced you to enter the plea. You agree with that?
Yes.
Okay. Ms. Cabrera, can someone in my office sign your name to the indictment?
Yes, Your Honor.
And Ms. Smith? Yes. Great. And Ms. McLester, is it okay if we sign your name on the indictment indicating your guilty plea? Yes?
Yes, sir.
Okay, great. I'm going to sentence you on, what was the range for riot? We don't get a lot of those.
Well, we got a bunch of them.
Well, we do actually get a lot of them, these big sprawling ones.
A bunch.
I'm trying to explain this. Yes.
You said it has to be one.
Huh?
Did you investigate when they come on?
Yes, I got a year left. Well, my remaining year.
Oh, she has you on an ankle monitor too.
Yes.
Huh. And
This is being that she required her to be on an ankle monitor for 2 years.
yeah, I'm just curious who pays for that?
Me.
You, good.
Yes.
That's what it should be, because we're not supposed to do county-funded ankle monitors post disposition. And a couple judges have been doing that, and that's driving. There's no budget for that. 1 to 20. All right, plenty of room. So I'm going to sentence you on counts 1, 2, and 3 to 4 years to serve 4 months. But you'll get credit because you did 4 months since your riot, because you were released. You get credit from June 23rd of 24, and you got released about 5 months after that.
He's giving you.
A little less than that.
He's telling you what your credited time is.
Right. So 4 years to serve 4 months with the balance on probation. So you're on probation for 3 years and 8 months,
Okay.
which is a teeny bit of the 19 years you're on probation with Judge Krause, but they're going to run concurrently at the same time. So that clock is ticking all together.
Okay.
You will need to complete 60 hours of community service, and you need to do that in the first 9 months of your probation. You don't have to do them all day one or month one, but you can make that happen. You'll also need to take an anger management course. Now, here you've already taken one. If you can get proof of completion, present that to your probation officer, and your officer may say, Oh, that works. But if what you did was dial 1-800 anger management and listen for 20 minutes, it may not be a legit
I
class.
actually have a certificate.
Good.
Yeah, I was in person.
Oh, you have it?
Oh,
Okay. So that'll probably check that box.
okay.
If not, don't get angry.
I'm not. I'm
Because you
gonna go back
manage
to
your
it.
anger. You'll just take another one.
Yeah.
So it's community service, anger management, and you do need to be gainfully employed. If you are not working after 3 months, then for each week that you're not working, it'll be another 10 hours of community service.
Okay.
So if you're not working, then you're doing community service.
That's giving me something to do though.
It is. It is. You just don't get paid a lot for that. After the first 2 months of your probation, if you are unemployed, for each week of being unemployed, we add 10 hours of community service.
Okay.
I think that's it.
Do you think you can get what he said?
Oh, right. Count 4 is,
Sent you? Okay.
sorry, I hadn't finished. I messed up. I forgot about count 4. That's 4 months to serve. That's concurrent with counts 1, 2, and 3. You already did the 4 months. So again, the total sentence is 4 years to serve 4 months, balanced, probated. And mostly, I hope, like you said, you've found new ways to channel your emotional energy. And you found new people to spend time with, because whoever you were kicking it with for these armed robbery cases, man, you lucked out, because those are 10-year mandatory
Make you do
minimums.
some crazy things, even if you ain't have no parts of.
Yep,
Telling
there you go. Stick with the girlfriend, and
Right.
hopefully that works out for you, okay? All right, anything else, Ms. Smith? Anything, Ms. Cabrera?
Nope, that's all.
Okay. Ms. McClester, does she need reporting instructions, or she already has the forever friend for the next 19 years?
I've actually reported and had a home visit since I've been.
Because she just had her revocation with Judge Krause last week.
Yeah.
So just contact your officer, because they're gonna need to go over
The new-
this case.
Okay.
So contact your officer and have her, let her tell you in the meeting, because she can go over this.
Okay.
All right? Good
Yes,
luck.
thank
I
you.
hope to only see you because you're working where I happen to be, and not because you're back in here.
Yes, sir.
Okay. You bet. All right, I gotta go. What can we do for Mr. Akins? There's a warrant. The warrant, it makes it sound like it's for a different shoplifting.
Yeah, it is not.
Okay, I can't print, I'm not able to see or print warrants.
Yeah, I can't either.
How do you know it's not? Just because you say so?
Well, his GCI doesn't show me.
Oh, okay,
That was what Stevens called me, that was the first thing I checked.
okay,
His GCI did not show me the rest since he got in September.
okay. I need to see the warrant to set it aside, but at a minimum, I can do something to help with the probation, which is to change the special conditions of probation.
So that he, can be on non-reporting status, while he's in drug court.
Okay, and do you have those case numbers? And can I just do an order, or does it have to be a special DCS? It'd be easier just for me to type something up.
Yeah, and then if once it's filed, I'll ask Ms. Nelson to send it to me.
Okay. So, Mr. Akins, I'm gonna enter an order. How many cases is he on probation? You're on probation for 1 case. I'm gonna change the condition of your probation so that you don't have to report to probation. Because you're coming to Hope Hall, you're doing what you need to do, when you're not getting hit by a car. This warrant, I gotta work on. I can't mess with the warrant today. So, you don't need to stick around. I don't have any pieces of paper I can give you. And the order for probation, you don't need to worry about it. That'll flow through the system. But that means probation will stop saying, you better show up. You got to report. Okay? Any questions? All right.
So you've already spoken with Officer Okuzu, right?
Yeah.
Yeah, so she's already advised him, he's good. So
Okay.
you shouldn't be in for a registration.
Good. If you do, if probation calls you, let me know and I'll reach out to them. But the order I'm going to enter is going to tell them to step back until you're done with drug court. All right. Be safe. I got to go. Can you just email me the case number and I'll add that? Thanks. Pardon me?
That's our only.
Okay, the lady, she needed to get more paperwork? Okay. All right, is it Rackard? Ricard? Rackard. I've signed it. You should be good to go. Good luck with everything. You bet. Thank you. All right, and for folks on Zoom, Ms. Rivers, Ms. Jackson, I'm gonna be back as close to 1 as I can, but it's probably gonna be more like 1:15. So if you could patch in at 1:15, that would be great.
Okay, no problem.
Thanks.
All right. Let's go. Let's go. Oh, man.
All right. Hey, Ms. Hall,
Good afternoon, Judge McBurney.
how are you?
I'm good, how are you?
All right, you're standing. Were you trying to go first or just Ms. Williams wasn't sharing the seat with you? She like slid in there and you were stuck.
You were right. Go first if possible. Oh, I just want to let you know I'm ready on Butler. I haven't presided on bond hearing for Tyrone Butler.
Okay, let me grab that. I don't have Mr. Butler on the bond. Maybe Ms. Nelson has another calendar she can send me. I have a bond calendar, but it's just Damari Marriott.
Yes.
Okay, there's another calendar. Okay, that's special.
Yes, Judge, Attorney Chris Alves on behalf of Mr. Butler. I also am here.
Well, then it must have been a calendar if you're both here.
There is, Judge, I will send it to you.
Okay. Well, I'm sure someone will email that to me. That wasn't in the stack of calendars I had. I'm glad you guys are ready. Also ready, though, is Mr. Dawkins. And we said we would do that first if we have all the people we need. Ms. Gordon, are you good with Mr. Dawkins now?
We're ready, whatever the court is, Judge.
Well, I was ready a while ago. I just wasn't here, but I'm here now. So let's do Mr. Dawkins.
Great.
Because we've got a bunch of folks stuck here for that. Now I have the Butler thing. I can write that down. We'll add that here. Okay. You can have this back now. Thanks. Good afternoon, Ms. Rivers. You good to go?
I am.
Great. Well, let's get on the record. This is 24 SC 004-605, State versus Sharif Dawkins. Hello, Mr. Dawkins. How are you today?
All right.
Good. I'm Judge McBurney. I don't think we've met before. You've been working with Ms. Gordon as your lawyer, and then Judge Ingram. Do you remember Judge Ingram? It's okay if you don't, but that's the judge who's had your case, and she is in trial right now. And so she asked me to help with this plea today. So I'm going to do that. We're going to have a conversation, you and I and Ms. Sellers, who's the prosecutor, about maybe pleading guilty. You were charged with criminal damage to property. You think you can go forward with that today?
Yes.
Okay. Ms. Sellers is going to put you under oath in a minute. You're going to raise your right hand and she's going to swear you in. You don't have to do it quite yet. And then she's going to ask you a bunch of questions. I need you to do two things for me. One, answer the questions best you can. And two, if you don't understand the question, let Ms. Gordon or me know so we can try to explain it to you. Will you do that?
Yes.
Excellent. All right. When you're ready, Ms. Sellers.
Thank you, Judge. Mr. Dawkins, please raise your right hand. Do you swear or affirm that the statements that you will provide to the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
You may place your hand. Please state your true and correct legal name for the record.
Sharif Ali Dawkins.
I need you to speak up a little bit. Use an outside voice.
Ali Dawkins.
Dawkins. All right. How old are you?
39.
39. How far did you go in school?
10th grade.
10th grade. Where'd you go to school?
Jonesboro High.
Say it again.
Jonesboro High.
Jonesboro High?
Yeah.
Okay.
Please state your full, true, and correct name.
Sharif Ali Dawkins.
Okay. And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Are you taking any medicine over at the jail?
Yes.
Tell me what you're taking.
Respidol.
Right, is that it? Just Respidol?
Yes.
Do you take that at morning or at night?
In morning and night.
Did you get it this morning?
Yes.
Does it help you understand what's going on when you take it?
Yes.
Does it make you sleepy or drowsy?
No.
Okay, you feel like you're understanding now?
Yes.
Great.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you are being charged with the following offense: criminal damage to property, the
Yes.
second degree?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges, to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment,
Yes.
including any potential defenses? Do you need any more time to discuss this case with your attorney?
No.
And are you satisfied with your attorney's services today?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
And do you waive any and all defects in the indictment?
Yes.
Has your attorney advised you of the minimum and maximum sentence available for the charge of criminal damage to property in the second degree?
Yes.
And you understand that this charge carries a sentence of 1 to 5 years
Yes.
custody. Do you understand that this is a negotiated plea of guilty, which means that the state is recommending the sentence of 2 years to serve, which is reduced to the time that you've already served. And that is the sentence recommendation to the court. But the court does not have to accept that recommendation. Do you understand that?
Yes.
And do you understand that the court has the full range, that 1 to 5 years, to sentence you to today?
Yes.
However, if the court enters a sentence that you do not agree with, you have the right to withdraw your guilty plea.
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Now, just one thing off the record, I know we didn't discuss, is he requesting to be treated as a first offender?
Does he qualify to your knowledge?
Let's find out.
Good.
The one time we need you.
12 cycles, no felony convictions.
Give me just one moment, Your Honor.
Yeah, because, yes, you should talk, because I'm going to follow the recommendation. There's no probation, so there's lower risk, but then he's using it. So it's an interesting situation.
Because you don't have a normal, you would be placed on probation, and if you complete your probation successfully, then get the benefit
Is Wood here?
Yes.
There's a drawback to it.
I have a
Could mess up.
probation petition for Mr. Leak.
Judge, do not get me started.
Oh, sorry. Did
Oh my
I
God.
pick a fight? But it's not what you were worried about.
Oh,
It,
trust. I know.
Okay.
I found out. I'm very upset about that.
you're upset with him,
With him.
with him. Good. You should be. He's a knucklehead.
Yes.
Does Ms. Williams know this?
No.
Okay.
I'll fill you in.
Well, justice is sort of settling in different ways. Ms. Gordon, did you have a chance to speak with Mr. Dawkins?
I did, Your Honor, and we would like to, he would like to use his first offender.
Okay, I'll chat with him about that at the appropriate time.
Mr. Dawkins, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
And have you ever pleaded guilty, a nolo, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on the first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for the charge in this indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
And do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty today, you are giving up the following rights? And I will go through a list of those rights. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand these rights that you are giving up today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
And it is your decision to waive these rights and enter a guilty plea because you are in fact guilty.
Yes.
How do you plead to the charge of criminal damage to property in indictment number 24 SC 004605?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
And if you believe there is some error in your guilty plea conviction, you do not have a right to appeal directly from your guilty plea. But if you believe there is some error in your guilty plea conviction, you can apply to the appropriate appellate court to request a discretionary appeal. And that discretionary appeal procedure is outlined in Georgia Statute 5635. And that discretionary appeal must be completed within 30 days of today's date.
Yes.
And do you understand that you have only 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
At this time, Your Honor, I will go on the record with the facts in this case. If this case were to go to trial, the state would prove the following facts beyond a reasonable doubt: that on May 16th, 2024, at approximately 8 a.m., Atlanta police officer Lowe responded to 950 West Peachtree Street regarding a damage to property call. Upon arriving on the scene, he was advised by Walden Security Officer Demetrius Williams that a male known as Sharif Ali Dawkins Dawkins was seen on surveillance camera picking up a concrete brick and throwing it through the Polk Works restaurant garage door entrance, completely shattering the glass, and that exceeded the amount of $500. The defendant, Mr. Dawkins, was still on the scene and was arrested and charged accordingly. And the Officer Williams was also able to provide surveillance video footage of the incident. And those are the facts of the case, Your Honor.
Okay, thank you. And we heard about criminal history, so let me turn to Ms. Gordon.
Thank you, Your Honor. We are asking that the court accept this plea as negotiated and that the court accept the plea under the First Offender Act. I think this is a case where, had there not been the competency issue, another client, another defendant likely would not have spent this much time in jail for this charge. So I do think that this is a good resolution here. Mr. Dawkins and I just had a conversation about first offender. I think he understands that he is getting the benefit of first offender by using it today and does not have to deal with the potential drawbacks of first offender because it is a time served and closed case. So he does want to use his first offender. We have spent some time looking for housing and services for Mr. Dawkins and had not gotten there yet. Mr. Harris, his social worker, was still making referrals when I received the offer for time served. So I have provided Mr. Dawkins with a pretty thick, several-paged resource booklet today. He has indicated to me that he believes he can go live with his sister, Courtney, who lives in Atlanta. He knows how to get there. So I told him, that's great. If for whatever reason you're not able to get there or you can't stay there, he's got this packet of resources with him. So hopefully he can use that once he is released.
Got it. Okay. Mr. Dawkins, where does your sister live?
I don't know. I don't know the address. I don't know the address.
How are you going to get there? Ms. Gordon just said you knew how to get there.
By walking.
Okay, but how are you going to know where to walk?
Well, I know where to walk. I know the directions.
Oh, you could get there if you were walking. You just couldn't say it's at 123 Walnut Street. Got it. How far would you say it is from the jail?
Probably about an hour and 30 minutes.
Oof, long walk, but you think you know how to get there?
Yeah.
Okay.
And I do think the jail will provide him with a MARTA card upon release, Judge.
They should, and that would be great. Do you know what kind of bus or train to take to get closer to your sister's house? No? Okay. But it sounds like you've got a plan.
Yes.
All right. And you would like to use first offender right now?
Yes.
You understand if you use it now, you can't use it again. There's just one first offender.
Yes.
All right. Well, you qualify for that. Ms. Sellers, was there any restitution? Or that's nothing you're exploring at this time?
The state is not exploring restitution at this time, Your Honor.
I think that makes sense. So, Mr. Dawkins, you'll likely be released tomorrow. You'll be ready your sister knows you may be showing up tomorrow.
Yes.
Okay. All right. Do you have any questions about anything we discussed?
No.
How are you going to get Risperdal when you're out?
Go to the doctor, go to the clinic.
Okay. You have a clinic in mind? Like, do you go to Grady or where did you go to get Risperdal?
Went downtown. I went to one downtown before.
Okay.
Penberg Place.
I think.
Okay. You know how to get there?
Yeah.
Okay. You don't need to know the address as long as you know how to get there. Well, Mr. Dawkins, I find there's a factual basis for your plea, meaning it sounds like the state could prove that you threw this brick through the window or the door of the restaurant, and that your plea is knowing, meaning you've understood things, and you told me you don't have any questions, and that your plea is voluntary, meaning no one's forcing you to enter this plea. Do you agree with that?
Yes.
Okay. Well, I find that Mr. Dawkins is competent to go forward with this plea and even to stand trial if that's what he wanted to do. And I base that conclusion on the opinion of Dr. Akaronu, who wrote a letter about you in August of this year. Dr. Akaronu spent time with you and determined from her professional opinion that you're competent to have the conversation we're having. And I'm adopting all of her opinions in her August 7th, 2025 letter as part of the record we're making today. Ms. Gordon, can someone in Judge Ingram's chambers sign the indictment on your behalf?
Yes, Your Honor.
Ms. Sellers?
Yes, Judge.
And Mr. Dawkins, is it okay if they electronically sign your name on the indictment indicating you're pleading guilty?
Yes.
They're going to do just that. I'm going to sentence you to the only count in the indictment to 1 year and 6 months. So a year and a half, that's 18 months in custody. You've done a little more than 19 months. So you've already done 18 months, which means they're going to let you out. Probably not today because the paperwork's got to move around, but tomorrow. And if you are still in jail and it's Thursday, you need to reach out to Ms. Gordon so she can bug me to figure out why are you still there. Okay?
Yes.
Does that make sense?
Yes.
Any questions about anything we've done?
No.
Hope you get to your sister's house. I also hope you stay on your medication because that's going to prevent you from doing things like what happened back in May of last year, okay?
And Your Honor, I've provided him as well on the back of this packet with 10 Park Place for medication, as well as the address and phone number for PAD.
Great. Okay, you got a couple resources out there, Mr. Dawkins, that'll help you out. You have a good holiday, okay? All right. Thank you, competency docket team. Sorry we're stuck in here a little longer, but it's good to be not in 7E. That place could be a bad influence on you. You get to see the real world out here in 8D. Be well.
Thank you, Judge.
You're welcome. Sorry we were a little late for plea number 2. Ms. Smith, what were we going to do with Silas Baker? I don't see Ms. Cabrera around anymore. Oh, it's going to trial? Okay. Trial.
Judge, I think she was going to get on the call, but I don't see her, but she did notify me that her client wanted to go to trial.
Okay, trial it is. We'll see them all on the 7th. That gets us to our afternoon calendar. Do we have a lawyer here who would be representing Mr. Marriott? He stepped out. All right, we're not going to skip it. We'll still do it. He stepped out. Ms. Powell's case was dismissed. Ms. Wood, of course, has already sent me something to seal it. Mr. Johnson, is Mr. Johnson here? Hey, Mr. Johnson, is your lawyer here?
Yes, good afternoon, Judge. I'm participating via Zoom.
Great.
Barry Jones for Mr. Johnson.
There he is. Good to see you, Mr. Jones.
Likewise.
I think this is on here more to move me forward as opposed to either side, although Ms. Williams did file something today or yesterday. I saw a notice of a Lafleur Fry. So why don't we just take stock of where we are? I think most of the onus is on me. Mr. Jones has filed a number of motions. We've argued them, and I need to rule on them. But I'll start with the state. What's cooking on the state side?
Good afternoon, Judge.
Hey.
Michelle Williams for the state. I did today file a Lafleur Fry notice. I spoke with the mother of the victim, Ms. Roy, and I didn't know if any offer had ever been made in the case, so I figured it's time to do that.
Okay, so it's your formal notification on the record of what you've communicated to Mr. Jones that he can then share with Mr. Johnson as to the state's offer.
Yes, Your Honor, it's the first notification to Mr. Jones. Mr. Jones and I haven't had a chance to speak yet, but I imagine that we will have a chance to talk in the future.
Okay, Mr. Jones, this is all happening on the fly, but have you had a chance to look over the state's filing?
Yes, I did review it and I shared the outline of it with my client. I haven't been able to give him all the details, but he knows there's a 20 serve 15. He is not interested I don't know if the court wanted to conduct a Lafley Fry hearing right now.
No. We would do that on the eve of trial. I just want to make sure you had it so that you could, one, engage with Mr. Johnson, and then two, you and Ms. Williams can start well, that's where you are and we're here, and see if there's a middle ground. But we don't need to explore that at this point. I owe both sides some rulings on pending motions. Was there anything else, Ms. Williams, from the state?
I do have, Mr. Jones, I do have a printed out copy of the Lafley Fry notice. Would you like for me to provide that to Mr. Johnson?
Yes, thank you.
Great. All right. You're not going to leave here empty-handed.
And then, Judge, on behalf of Mr. Johnson, the only other thing is that we do know who the mental health providers are to the alleged victim in this case. So I would like a BOBO hearing scheduled in the future so that I could subpoena them and we could handle that at a later date.
Did you file something, or you just put that in context? That's something that's already before me, or you now have learned that there are potential counselors, therapists, mental health providers for the child?
Correct. And then I filed something previously addressing the BOBO issue in a previous motion. So there is something before the court, but at that time I did not know the identities of the mental health providers, with the exception of one. Now there are 3 or 4, and we'd like a future hearing date to address that issue.
Got it. Let me look. Okay, I see it. It looks like in June, a motion for production of reports. Okay. Got it. I will look at that, decide if we need to have a hearing, and it may be I'm required by law to have one, and certainly get a ruling in on that. Okay. All right. Anything else on the defense side?
No, Judge.
Okay. Well, I will add that to the list of things I need to take care of, and make some progress with those things so that when we next convene, both sides will have a better sense of what's coming in at trial and what's not. Once I get those rulings in place, Mr. Jones, any reason you would not, other than you're busy, you would not be ready for trial? In other words, are there pieces of discovery you're working on, or you're ready to get into court as soon as we can tee it up?
Yeah, I mean, once we have all those issues resolved, subject to our experts' availability, we'd be ready for trial.
Okay, well, same with the state side, so it's witness and lawyer availability. Okay, then I know what I need to do. Mr. Johnson, do you have any questions?
No.
Okay, well, if there's nothing else, then thank you both for being here.
All right, thank you, Judge.
Thank you, Judge. I believe that completes my business. May I be excused?
Yes, ma'am.
Thank you.
Thanks. And then Lane Hammond, hopefully no one's here for Lane Hammond. That got reset. Quadine Hardison.
You should be on the Zoom, Judge.
All right. There's Mr. Hardison. Okay, are we confirming, was this intervention through the DA's office, or it was a court-administered PTI?
Court-administered virtual PTI agreement, Judge.
Okay, but it's real, it's not virtual. We're not calling it that anymore. We are calling it pretrial intervention. It's just not DA. I don't know, we'll come up with something in 2026, but it's not virtual, other than that your client is virtual right now. How is he doing with it?
My position that he has completed all of the terms. The terms for him were to maintain employment. He's sent in 2 separate pay stubs to confirm that he's been working this whole time. And then there were 25 community service hours. He had sent in a document from an organization. The person who supervised him is no longer there. I spoke to her last week. She confirmed. I think part of the issue for the state is that she was unavailable yesterday, and also her email no longer works because she doesn't work there anymore. So I haven't been able.
Where's there?
It's Cafe Momentum, I think is the name of the thing.
What would community service be at Cafe Momentum?
Well, Judge, let me bring up their website. They have a whole thing, mission to transform young lives by equipping our community's justice-involved youth with life skills, education, and employment opportunities to help them achieve their full potential.
Cafe Momentum Atlanta.
There you go.
Closed right now, but maybe that's just a Tuesday thing. Okay, they're open Wednesday through Friday. Mr. Hardison, what did you do at Cafe Momentum?
They had like events, and I would just help like set up the events and move whatever they needed to move as far as like silverware and plates and stuff.
Okay. Did you ever eat their food?
Yeah, their food is pretty good. They got like their own batch of cookies that they make and stuff like that.
Yeah.
So it was a good experience.
How many hours would you say you worked there?
Probably about, I did probably about 3 or 4 days at about 25 hours.
Okay. So what are you doing to get documentation that you did that?
So there is a letter that was sent in.
Oh.
So the issue, I think, is so he completed these hours over the summer.
Yeah.
And then there was a delay because I'll fall on the sword here. I did not reach out to confirm at the time. In that interim, the lady who signed off on it no longer works there. So
But it's a letter on Cafe Momentum letterhead and everything?
Yes, Judge.
Okay.
So I spoke to her on her cell phone and she confirmed she remembered him, all of that good stuff.
Yeah.
But of course, I understand Ms. Smith would like to speak with her herself and just hasn't had the opportunity to do that.
Okay, but you have contact information for her so that Ms. Smith can do that.
Yes.
I spoke with her, Your Honor.
Oh, what were you gonna tell us this? You were going round and round? Because it wasn't your turn yet. Okay.
Right.
So you spoke with this person and she confirmed that Mr. Hardison did the 25 hours?
Yes.
Or at least confirmed her letter?
Right. I spoke to Shakira Crenshaw, who said that she was the assistant general manager at this location. However, there were a couple of discrepancies when it came to the letter that was submitted. It was previously submitted to 88 Davis that did not have a letterhead on it. The word momentum was spelled incorrectly, and it was seemed to be not a valid letter that came from Ms. Crenshaw. We also checked on the website and there's no assistant general manager position listed. So we did get a chance to speak with her, and yes, she validated the letter. However, the state does not believe that the letter is valid. Also, when we tried to email the email address, it came back as, name server user not found. We believe that's because the domain is spelled incorrectly because it's not an actual email address from Cafe Momentum. We've attempted to reach out to Cafe Momentum to speak with the staff that they have now, but they're not open until tomorrow. So the state will reach out then. However, if her employment is not verified through Cafe Momentum, the state will be asking for the defendant to complete those 25 hours elsewhere, because at this moment, we do not believe that the 25 hours that is accredited to the work he's done at Cafe Momentum is indeed a valid effort of
Got it. So you'll reach out to management at the Atlanta Cafe Momentum to say, hey, does this name ring a bell? And if they say there's never ever been someone with that name who worked there, then Mr. Hardison pulled a fast one.
Yes, Your Honor. Also, when I spoke to Ms. Crenshaw, she informed me that the company completed a verification form for his community service. So in addition to calling tomorrow to see if he was indeed an employee, we'll also be asking for that verification form. We just want to make sure that the defendant, and cross our I's and dot our T's, that he actually completed the community service.
Okay. And what about the gainful employment? Have you seen anything that documents that Mr. Hardison's been working?
Yes, Your Honor. That we don't have any complaints about. We did get verification that he has employment.
Okay, then why don't we do this? We don't need to have people come back to court. You can shoot an email to me and Ms. Nelson and Ms. Wood saying, here's what I learned from talking with people at Cafe Momentum. And it's good news for Mr. Hardison or it's bad. And if it's bad, I'll take it under advisement as to whether it'll be 25 hours or maybe more, because this wasn't a legit thing.
Okay.
Does that work for you?
Yes, it does.
Ms. Wood, any concerns about that?
No, Your Honor.
Okay. Mr. Hardison, did you follow all that?
Yeah, I got it.
All right. So Ms. Smith is going to check things out. She's just doing her homework, which is what she's supposed to do. And if everything checks out, then we'll close out your case. If it doesn't check out, then we will not close out your case. We'll expand it a little bit. Okay?
Okay.
All right. Where are you right now?
I'm headed to work.
What are you doing now with work?
I'm a manager over at CBS.
A what?
A manager over at CBS.
Oh, all right. Which CVS?
4600 Roswell.
Okay. All right. We'll get to work. And Ms. Wood will be in touch.
All right. Thank you.
I don't know the last thing he said, but I'm sure it was nice. So all I've got left is the Butler bond hearing, which we'll do, and then the Marriott bond hearing, which we'll do, and then Kuykendall revocation. Any people have other things? Am I missing a calendar? No. Hello, sir.
Good afternoon.
Good afternoon. I've been waiting. Curtin Matthews, he's not listed next to any of these defendants. Surprise cameo?
Yeah, thank you, Your Honor. So I understand that Your Honor is presiding this afternoon.
Maybe.
So I've been able to reach a consent bond agreement with the state of Georgia. I am waiting for the district attorney to approve the order. And
The district attorney, as in the district attorney, or the ADA you're working with?
the ADA that I'm working with.
Who is?
Torrance Mill.
Okay.
And so I'm waiting for his response. And as soon as that response comes in, I'd like instructions from the court in terms of how I get that proposed order to be drawn.
This is an unindicted case?
Indicted. However, Judge Schwall, they've indicated that they have no objection to me having Your Honor to consider.
Okay, as long as you did your homework, as long as that judge is saying, I can go home now and make McBurney do it, then I'm happy to deal with it.
Absolutely.
Okay.
Thank you. So would I get that to Your Honor through digital or do I have paper to leave?
You are welcome to email it to me or someone on my staff. The risk you run is if I look at this and say, this doesn't seem like the kind of bond I'd sign, I'll need to be able to interact. And I'm fine emailing you and the ADA saying, help me understand this or that. Electronic communication is great by me. Just know that I may have questions.
Okay, I understand, Your Honor. Thank you.
And I'm assuming your client's not in the building. This is all work that the lawyers are doing. Okay, all right.
Thank you.
You bet. So let's handle Mr. Butler. Hey, Mr. Butler. I'm doing all right. Give me 1 second. Okay. We're going to get on the record. This is 25 PI 009708, which is the state versus Tyrone Butler. Mr. Butler is now in court with his lawyer, Mr. Alviz. Mr. Abadi, you handling this for the state? Okay. Ms. Hall had been here. You dismissed her? Yes. Okay. All right. So we've got a representative from both sides. And Mr. Butler, all we're doing today is sorting out bond. So your lawyer is going to articulate why you ought to have a bond and what that should look like. Mr. Abadi is going to share with me maybe a little bit about what he understands the case to be about, and the state's position on bond. If there are any family members of, oops, that's the wrong page. Mr. Holmes, I may hear from them. I will hear from them if they want to be heard. And then I'll wrap up again with your attorney having the last word as to what we're going to do. And I'll let you know. As long as your case is unindicted, questions about bond will stay with me. Once it is indicted, it's going to be assigned to some judge, and that'll be the judge who's dealing with bond and everything else with the case. All right? Counselor, when you're ready.
Of course, Judge. Judge, my client, Mr. Butler, is 62 years old, born and raised here in the state of Georgia, Judge. He lives here at the address listed on the booking sheet with his daughter. He does have his entire family here. His sisters, his brothers, his wife, whom he's been legally married to for the past 37 years, and his 2 adult children. His daughter mentioned earlier, 36, and his son, who's 32.
He lives with his daughter. His wife does not live in that household?
My apologies, Judge. That is the daughter's house. So him and his wife both live there with his daughter, Judge. And again, they've been married for 37 years. He did reach the 11th grade at Bass High School. However, he did attain his GED. He was gainfully employed up until his most recent incarceration, Judge, with Cater Blessing. That is his wife's business, of which has been in perpetual business for the past 20 years.
It's a catering company?
Yes, Judge, that's correct. And with that being said, I know today is only about bond and not related to the circumstances of the matter, Judge. I will just...
They're not completely divorced from each other.
Correct.
But I don't think have you had a preliminary hearing yet?
No, not
So
at
you
this point.
know precious little about the case.
Correct, Judge.
And I appreciate that fact.
And with that being said, I would just like to point out to the court that at this point in time, my client is innocent until proven guilty, and he will leave this courtroom presumed innocent, Judge. With all that being said, I would ask for a bond to not exceed a total amount of $100,000. Unfortunately, there's no amount that can be put on the back of the loss of life, Judge. However, I believe given the length of my client's ties to the community, the fact that he has a majority of his family living here in the state of Georgia, that he does have an address to which he could return to, that he does have employment to which he could return to, I base that number off of that set of circumstances that I put forth to the court today, Judge.
Sure, and it's not an insubstantial amount. It's a big number.
Unfortunately, though, no amount of money can be placed upon a life, Judge. Again, with that being said, though, I would ask for a bond to not exceed $100,000.
Okay, appreciate it. Before I hear from Mr. Abadi, Ms. Jackson, did you have a chance to look up any criminal history for Mr. Butler?
Yes, Your Honor.
And what did you find?
23 cycles. The last arrest was May the 29th, 2018, out of Cobb County for entering an automobile and battery, and 2 counts of aggravated battery and theft by taking and financial or transaction card theft and financial or transaction card fraud, and an additional case of theft by taking. He does appear to be on probation out of Cobb County for 2 counts of aggravated battery. That disposition date was May the 1st, 2019, and the term is for 7 years. There are prior felony convictions, one in 2011 out of Cobb County for entering an automobile and theft by taking and possession of tools for commission of a crime, in financial transaction card theft, and 2 counts of theft by receiving stolen property. There was one in 2008 out of Cobb County for possession of tools for commission of a crime and entering an automobile. It's one in 2003 out of Cobb County for cruelty to children in the first degree. There was one in 1993 out of Henry County for robbery, one in 1986 for robbery, one in 1984 for aggravated assault, and one in 1981 for burglary. And there are misdemeanor convictions. One in 2000. One in 2000.
I'm good. The felony list was enough to get me up to speed. I appreciate all that.
Yes, sir.
Thank you, ma'am. Mr. Body.
Yes, Judge. The state respectfully requests you deny defense counsel's motion for bond. You just heard the defendant's criminal history. So I would submit to the court that he is a significant risk of committing felonies pending trial, as he is a 9-time convicted felon. Not only does he have a hold out of Cobb County for his probation violation, but he also has a parole hold for a parole warrant that existed prior to this incident on 11/26 of this year. I would submit to the court that he is additionally a significant threat or danger to the people in the community in it. This entire incident is caught on video where the victim is waiting outside of the address, which is 1271 Marietta Boulevard, Northwest here in Atlanta, over on the west side, I guess. And it's Vivid Nightclub. Victim was waiting for an Uber. He had some drinks that evening. He ended up missing his Uber and remained seated in front of the club. The defendant walks by the victim and they have some words. They separate, and then the victim is in the parking lot. The defendant reapproaches them after putting his hood up, and he bumps his shoulder in an attempt to get the money that was in his pocket. There is a physical altercation after the defendant bumps the victim, and then the defendant pulls out a knife and stabs the victim several times. At that point, he takes the victim's money and phone that were on the parking lot floor, and the defendant then walks away. The victim, in an attempt to get his items back, begins to walk towards the defendant, who then turns around, and before anything happens, the victim actually falls onto the pavement, and the defendant walks over him and then stabs him again. At that point, he then leaves and takes off. There is obviously the detective is able to quickly get the video back the very next day, or I guess the same day. So, because this happened in the early morning hours of the 26th, the detective, because it's so high definition, is able to recognize the defendant as walking in the same area. At that point, places him under arrest. Defendant gives him a fake name and date of birth, as well as a fake, it's a real ID, but it wasn't his ID. And at that point, he's placed under arrest. He makes a statement to the police. He admits that he did everything that I just described, said he did it in self-defense. And the money that was actually taken off the defendant's person, as well as the knife that he used to likely stab the victim, are collected into evidence. The money has blood all over it, showing that the money was likely the victim's in this case. It's all been submitted to the GBI for testing. Based upon all of that, the state would respectfully request you deny the defendant's request for bond today.
Okay. Mr. Alves, I know some of that may be brand new to you. Obviously, it's all new to me. All I knew was that Mr. Holmes had been stabbed. So there's some context there presented from the state's perspective. And also front and center is the fact that your client enjoys the presumption of innocence. Right next to it, front and center, is on probation when this happened, hold out of Cobb, parole hold. So there's some wrinkles in there for him. But before I ask you to respond, if you want to respond at all, I forgot to close the loop and ask Mr. Bate if anyone from Mr. Holmes's family wanted to be heard, or if you had words to share on their behalf. I didn't mean to skip over that.
And I apologize too. The victim's sister, Miss Kimberly Holmes, wanted to make a very brief statement to the court.
Okay. Ms. Holmes, if you'll come on up and follow Deputy Gordon's direction as to where to walk and stand.
Hi, my name is Kimberly Holmes, KIMBERLY HOLMES, the sister of Evan Holmes. Due to the violent nature of this heinous crime, I think bond shouldn't even be an option. The defendant has a lengthy criminal history. He has zero ties to the community, so I believe he is a flight risk. Our family has been absolutely devastated by the loss of my brother, and again, I believe this defendant should not have a bond. Thank you.
Thank you for being here. I'm sorry for your family's loss.
Thank you.
Anything else, Mr. Body?
No.
Okay. Mr. Alves.
Thank you, Judge. I certainly don't understand the pain or the difficulty that the victim's family is going through at this point in time, and not to minimize it in any way, shape, or form. That's not what this is about. However, Judge, I understand that the court at this point in time has heard from myself, the state, and from a representative of the victim's family. With that being said, Judge, I still would ask for a bond to be set in this matter. I stand by the argument that I made earlier, Judge.
Okay, I appreciate that. Mr. Butler, it is early in the process. It will be a lengthy process wherever it ends up. But your lawyers, and you may end up having more than one because this case may transition from Mr. Alves to a lawyer if and when the case gets indicted. It will be a colleague of his. They will learn more about the case and will be in a better position to provide more context to what this is all about. But based on what I've heard about your more recent criminal history, it's not great that in 1986 you had a robbery conviction, but I appreciate that that was 40 years ago, and that's not who you are today. But you are on active probation for an aggravated battery ×2. That's a crime of violence. You've got a parole hold. And those are all situations that say to me that bond is inappropriate till those other things are sorted out at a minimum. And not until your lawyer or lawyers have an opportunity to watch some of this video, et cetera. The proffer of facts, of evidence from Mr. Abadi makes me worry about your safety and others, given the situation you got involved with and the outcome for Mr. Holmes. And then the criminal history piece makes me concerned that you might not stay out of trouble while you were on bond. I do see that you have connections to the community. You're a Georgia native. Your wife has a 20-year business that's based not in Fulton, but it's local enough. It's not based in Las Vegas. So there are ties there, but there are these countervailing influences of what you've been up to in the last few years and some of what we just heard from the prosecutor. So at this point, I'm going to deny bond. But as I told you at the outset, unless and until you're indicted, Mr. Alves knows he can come back here after he's received new information, different information. If there's any change in circumstances, we ought to revisit this. But as long as things stay as they are, with not one but two holds, et cetera, I'm going to keep you where you are and let your lawyer start doing the work that needs to be done in your defense. Thank you.
Thank you, Judge. Judge, may I be excused?
You may. Thank you for being here and sorry to keep you waiting.
Yeah.
So are we ready to talk about Mr. Marriott?
Yes, Your Honor, David Howell happens.
Mr. Howell, come on up.
Yeah.
1 second. All right. Mr. Marriott, how you doing?
Good, sir. How are you?
All right. So we're going to get on the record in your case. It's 25 SC 006. And your legal team, you got a couple lawyers helping you, filed a motion on the 30th of October to have someone look again at bond in your case. You were denied bond earlier this year. Your lawyers have asked that someone look at that again, and that someone is me, since this case is assigned to me. So I'm going to start by having your lawyer talk to me about why bond should be set, what that should look like, and then I'll hear from the prosecutor, and if there are any members of the victims' families in this case, I can hear from them as well. So when you're ready.
Your Honor, do you prefer a sermon from the podium or?
I prefer that Ms. Rivers be able to hear you. So as long as you're speaking into that microphone, you can be at the podium or right where you are. Either way works for me.
Very good. If you would. Your Honor, David Howell on behalf of defendant Marriott. Mr. Marriott has been in jail since pretrial since 12/29 of 2024. So we are approaching 1 year in custody as an innocent man. One of the most fundamental premises of our criminal justice system is that a person ought not to be punished for a crime prior to the state proving each and every element of the charges against them beyond a reasonable doubt. And if the right to pretrial bond is not preserved by courts across the state, then the presumption of innocence, secured only after years of struggle, would lose all of its meaning. My client, Mr. Marriott, is 20 years old. He was a lifelong resident of Georgia. However, he moved to Florida shortly before the incident that in question in this indictment. He moved down there to live with his brother as he wasn't getting along with his father. He does not have any criminal convictions, and he has a 10th grade education. One of the reasons he moved down to Florida was also so he could go to college, and he was attending a technical school down there. He has a work history. He was working in Florida at Denny's restaurant. Prior to that, he was working at Warehouse Dynamics in Marietta, and then numerous fast food jobs before that. He has strong family ties to Georgia, including his aunts and uncles. His mom and dad both live here. And we believe he's an excellent candidate for bond.
Would he, if released, be in Georgia or Florida?
Wherever the court would want him, he would make sure that he could be there. He could live with a family member here.
Okay. What is it you're advancing? What location? And you don't need to say 123 Main Street, but you're advancing the household with his brother in Florida or a household in Covington
I
or?
would say it would be with his mom here in Georgia.
Okay.
Which is in metro Atlanta area.
All right. The system here says that Mr. Marriott was booked in on April 25th. So that shaves about 4 months off what you're describing. Was he in some other?
I was about to April 10th.
Okay. It was wrong. It's in my notes. I have the date wrong, but
No, it's okay. There is a date in here of the 29th. There's also a date in here of the 9th, which is probably a typo. But the booking number and booking date is April 25th.
he wasn't arrested until April.
Okay, it doesn't make any of your points any less important about the presumption of innocence and bond not being punishment. I just want to make sure there isn't a missing 4 months somewhere, because at some point in these proceedings, it could become very relevant if he gets credit for time he's been in, if he ends up in a position needing to get credit for that. Okay, so April it was.
Right. Your Honor, we're asking the court to set a reasonable bond. We believe that conditions can be set which would allay the state's concern. Should they have a risk of flight? Should they have a risk of intimidating witnesses or committing other felonies?
Okay.
I believe that given his history, he's an excellent candidate for bond.
All right, thank you. Ms. Jackson, any adult criminal history for Mr. Marriott?
Yes, Your Honor. There's a total of 3 cycles. Well, not really. You just have that fugitive arrest out of Florida on April the 10th, 2025. Nothing other than that.
Got it. So that's the April 10th date I'm hearing from Mr. Marriott. And then it took 15 days to get to Rice Street and get booked in there. I mean, he's been in custody since April 10th. Some of it was transit.
Correct.
Okay. All right. Mr. Abadi.
Yes, Judge. I would respectfully request you deny defense counsel's renewed motion for bond. Not only was bond heard by Judge Carnicel on May 13th, I believe, of this year, 2025, where she denied bond and found that the defendant was a danger to the community and a risk of intimidating witnesses, but you actually have heard this bond before back on July 15th and denied the defendant's
Mr. Apt is persistent.
bond at that time, finding that Mr. Marriott was a significant threat or danger to the community, posed a significant risk of committing felonies pending trial, and posed a significant risk of intimidating witnesses.
Was this in, I'm sorry to interrupt, I just want to track all that. I think Mr. Hiles re-indicted this. Was Mr. Marriott in the original? He's not an add-on to the indictment.
No, it was in the bond orders in the original case, number 25 SC 003438.
Great, I'm looking at it now. Okay, thank you.
And I guess the state's argument is hearing no change in circumstances since his bond was denied before Judge Carnicel and then before Your Honor in July of this year. The state respectfully requests you deny defense counsel's motion for bond. I'm sure you heard this on the 15th, but he was out on bond for a gun charge out of Cobb County. He was arrested. I think it's a misdemeanor, but he was carrying a concealed weapon. And he was arrested February of 2024. And then this incident happened December 29th of 2024. And you're familiar with the facts of this case from the other bond motions that we had, so I won't belabor the point. But I will bring to the court's attention or re-attention that this defendant was the setup person. He was friends with the victim, Mr. Barnesdale, and lured him to the location. There's several Instagram messages between him and all of his co-defendants where he is talking about basically taking him down. He said that that was their plan, was to arm rob them, take them down. There's a slew of messages where he is the person who is initiating all of the conduct that led to the death of Mr. Monisdale. So nothing further from the state.
And as I'm reconstructing my memories of these things, there are actually two lure rob murders. Ms. Jones is the lure for one, and Mr. Marriott is all alleged, is the alleged lure for the other.
That's correct.
And it is Mr. Byrd who is involved with both.
Yes, Your Honor.
Okay, all right. This is all coming back. Thank you for sharing that. I want to make sure you've got the last word. I'm remembering a whole lot more about Mr. Marriott and the circumstances of the case. I remain mindful that these are allegations and nothing's been proven, et cetera. What I'd love you to focus on in particular, if you have anything to add, is what is different other than, I don't say other than to minimize it, other than the passage of time from July 15th. So 7 to 12, 5 months ago, I signed an order saying no again to bond. Judge Carnesale did that initially. And then on July 15th, hearing from either you or Mr. Apt, or both of you, maybe ganged up on me, hearing the position of the defense, I denied it. And generally, we don't revisit these things unless there's been a change in circumstance. This may have slipped through, or there may be a change that I didn't pick up from reading the motion that Mr. Apt filed of what's different other than, and again, I'm not minimizing it, a guy presumed innocent, a young man, has been sent in jail for 5 more months, and here we are.
Very good. Your Honor, this is the passage of time is kind of the crux of our motion. However, I'd like to add this. I'm sure the court's aware that the place where Mr. Marriott is being held is under a federal consent decree right now, where the special master who's balancing the equities of, the consent decree has found that if you're going to be held in Rice Street, you're going to be held in unconstitutional conditions. This is not the Mulberry City Jail where they're bringing you food every day. This is a place where you're fighting for your life every day just to survive. People get eaten by bugs. People get murdered. There was a fire the other day where 10 people were drug out of there on stretchers. 2 of them are on a ventilator. One's in critical condition. This is not your average jail. And if you or I were there, even in certain circumstances, we know the legal system. We know the rules around bond. We'd be calling our attorney every day saying, get me out of here, because it is dangerous. And I think the most critical element, it is, if you are going to be held in the Fulton County Jail, it is almost certain you are going to face unconstitutional conditions of confinement. That is if that isn't a change in circumstances, then I don't know what really would qualify.
Well, sadly, I don't know that it's a change in circumstances. It's just dire circumstances, meaning I don't know that it has suddenly, in the eyes of the monitor and the district judge from Northern District of Georgia, that it's become suddenly unconstitutional conditions over the last few months. It's been that way for a while, hence the monitor. So I'm not quibbling with you other than to say, I don't know that that's really changed from the day Mr. Marriott got there.
I would say it's changed in the point that now an independent monitor has said that, as opposed to, 2 parties arguing. Nevertheless, whenever I do these hearings, and I do them all over, always reread Ayala and the progeny of cases that come thereunder. And, how do I describe it to families and to people who aren't always in the justice system? What I say is we're here on a balancing of the equities. What we're balancing is my client's interest in justice versus the state's interest in protecting the public, and foremost, ensuring my client appears for trial. And if you read Ayala and the progeny thereunder, what you see is the amount of bond is what secures the defendant's attendance at trial. Okay? The conditions of bond are what protect the community. If the state is alleging, as they have, that there were communications sent, to alleged victims or victims' families or witnesses, well, the court can certainly prohibit, prohibiting.
Hope that he's never gonna bump into an electronic device while he's on bond.
I'm not saying that, but what I'm saying is if the state came forward with any allegation that he was using a device, well, the court could revoke his bond. My first job, when I graduated college, is I was selling cars. And I'm telling you this because when people come in without any credit in the justice, any credit, it's hard to sell them a car. It's hard to get a bank to put a loan against them and say, take a risk on me, because they don't have any history. Likewise, if he had been in and out of the justice system, and I could come in here and I could say, he has no FTAs. He's completed probation. He's a model citizen that responds to court process. That can take something that looks bad and turn it into a good fact. I don't have that here because he has no credit with the justice system, and I don't think that should be held against him. I think he should be, the presumption of innocence trumps, a lot of what the state is saying. I think he deserves the opportunity to get out there and earn the court's trust. And if he breaks it, the state has a remedy for that. But I believe he's owed the opportunity to prove to the court that he is responsive to court orders and process.
Okay. Do you know if Mr. Apt has picked up the hard drive full of discovery? You guys have discovery.
We do.
Because the state has been working hard at my direction to fill these hard drives. And I think there was one lawyer, but it's clearly not Mr. Marriott's team, that hadn't followed through on getting that hard drive and then picking it up. So you guys have discovery and you're underway digesting it to see if there are evidentiary motions we need to work through before this can be declared ready for trial.
Correct.
Okay, good to know. All right. Mr. Marriott, do you have any questions about any of the things we've been talking about?
No, sir.
Okay. All right. Mr.
I do got one question.
Ask me first.
About me being, because they get accused.
Judge, while they're talking, when I finish, can I make one more statement to the court?
Yes, but if they need to hear it, don't say it quite yet.
I'm waiting.
Okay. Not a question for me?
Not a question for you, right?
Okay. All right. Mr. Body.
I neglected to inform the court as well. 3 days after you denied his bond on the 18th of July, the defendant attempted to extort another inmate by holding him at knife point, saying that he better give money by the end of, whatever day 2, or he would be subject to, violent behaviors by him and his fellow inmates. So I just wanted to make sure the court was aware of that. After your first denial, that was the response.
And you are able to share this because of reports it's reports from sheriff security or jail security or whatnot.
It's on the jailing screen.
Okay. All right. Can you make sure you pass that along to Mr. Howell and Mr. Apt, just so they've got that?
Sure.
Thank you.
I'll send all of them.
Okay. So Mr. Marriott, independent of that, I'm not changing the status right now, but I do, that's problematic if that plays out. And so, Mr. Howell, I guess that would be a change circumstance in the wrong direction, but you're just learning about it for the first time. So you should take a look at what Mr. Body shares, and you don't need to try to rebut it right now or even after you get it, because that's didn't help. But I wasn't going to change things anyway based on where I think we are in these proceedings and what I think is necessary to protect the community, ensure that Mr. Marriott doesn't get mixed up in something like this case in the interim, and in particular keeps witnesses and others who might be involved with the ultimate trial away from any influences they shouldn't have at this time. So we're going to keep it as the status quo. I do intend early next year, so in just a few weeks, to reach out to all the lawyers to have a status call to see what's next, so that we're moving this along. I have tried hard to keep everyone moving at the same rate, but it's a whole bunch of defendants, and we may start to have a tier of lawyers who say, we're ready to go. And we may need to be ready to go with those and let the others catch up as they can. Anything else on behalf of Mr. Marriott?
Nothing from the defense.
Okay, anything else on behalf of the state?
No, Your Honor.
All right, thank you all. And again, I'm sorry that we got a late start.
Your Honor, that concludes my business. Have an excuse?
Yes, sir.
Thank you.
Judge, that also concludes my, may I be excused?
You may. We're going to do Mr. Kuykendall in 1 minute. I got to look at this. Okay, I'll trade you. Ms. Allen? Hey, I'm going to give this to Ms. Simpson. She's going to get it to a deputy who will get it to you, or she may get it directly to you, but I signed off on this, okay? I hope you're doing okay. Good. Pardon me? Yeah. No, that's good. That can go. I'm just gonna have my staff attorney take a quick look at this. You're here with that? Okay, great. I just skimmed it. It should be good to go. She's just gonna look at the math and make sure there's no funky procedural requirement. You're just posting a bond to get a lien off something. Okay.
Thank you.
So I think all that's left is Mr. Kuykendall?
Yep.
Before he comes out, so what's cooking with him? He
agreed to.
I remember who he is. He'll be new to you, Miss Smith. But then you'll always remember him after you meet him.
Very pleasant.
He is? I didn't ever say he wasn't. Okay.
He's on.
Oh, he's in a better medical space?
He's on night and day.
Medicinal space. He was in Vegas for a while. He was in California for a while. And the whole notion of that, I guess he got transferred to California and it didn't go well.
And then he never reported to California, and then when our investigators called him, he was in Las Vegas.
Yeah.
And then they were like, yeah, you need to make your way to California. He was like, I'm on the road, I'll figure out how to get there, and then we never heard from him.
Well, I have a little bit of different backstory.
Okay, well, we'll get him out here. But you all have spoken with Ms. Smith and you think you're in a space to resolve this?
Yeah, you are on all.
That's fine.
Okay.
Yeah, that's fine.
Okay, let's bring Mr. Kuykendall out. Okay. Let's get on the record in Mr. Kuykendall's case. It's 24 SC 0000888. Welcome back. I haven't seen you in a while.
It has been a while.
It has been a while. So, Mr. Kuykendall, you pled guilty in this aggravated assault case and had your probation transferred to California. At least that was the plan originally. And Ms. Rios is going to tell more of what's been going on. But what was relayed to me in the warrant that I signed back in July of this year was that California reached out to you and you said, I'm not in California, I'm in Vegas. And California said, well, that's not where you're supposed to be. You're supposed to be with us. And in essence, you said, well, I'll get there when I can get there. And that doesn't work. And California said, Georgia, we're not interested in supervising this person who won't come in and report. So we're going to work through today where it is you're going to be supervised, if you're going to continue to be supervised. I need to find my magic email that I got. Here it is. So you've got a little less than 9.5 years left on probation. So there's a lot to work with here. And we need to figure out how we're going to work with it. So I think what I'm going to do is start with Ms. Rios, and she can talk to us about what she thinks has been going on, and then I'll hear from everyone else.
Yes, Your Honor. So Mr. Kuykendall had been really good about keeping up with informing me what was going on. So that whole time we had been in conversation because initially the place that he told him to report was really far out. So he was having trouble getting there. Once he got there.
Really far out in the state of California?
Like it wasn't near where he lived. So
Okay.
when he got there, and he was trying to explain to him that it's not a convenient location, and can they switch to another location? There was some going back and forth.
Where in California is a big state. So where were we in Southern California?
Right?
Yes.
What was the city?
The city was Pomona, and I was in Hollywood.
Okay.
So, and they were telling him information about, like, it was confusing because they were telling him it was parole, not probation. So that was confusing to him. And then he was like, I want to go back to where my mom lives. I want to go back to Las Vegas, Nevada. But they were telling, initially they thought that he could do a transfer, or like he wouldn't have to come to Georgia. Then I talked to probation. They was like, no, we thought maybe we could transfer. They're in Nevada saying, no, he needs to come to Georgia first. And then we do the transfer.
So he would, to transfer from California to Nevada, adjacent states, he would need to go back to Georgia to basically have Georgia say, thanks, but no thanks, California. Nevada, would you supervise him?
Yes, Your Honor.
Okay.
And he did not have money to get to Georgia at this time. His mom wasn't willing to help financially with that. So he was like, I can't afford to get to Georgia. So I was like, well, they're probably going to pick you up, and that is what happened.
And that is what happened.
And so, but now his mom has been calling me a lot. She actually found the plan was for him to go live with her, but she found a place for him to go, a mental health component, drug component rehab place. She just sent me the information.
So this is a treatment facility.
Place. She just sent me the information because she would prefer him to go there. He's been doing so well since he's been on his medication. I was also going to ask the court to maybe order him to be released with some supplies so he can get started off with, well, not supplies, his medication, to start off with that before he can go get it. She has said she's paid for a hotel for about a week for him to stay here. If the transfer takes longer than that, which she knows it likely would, then he's going to go to PAD. He already did a referral to PAD, so he'll have the hotel for a week at the extended stay. If it takes longer, then he can get housing through PAD until the transfer takes place. And then he's going to go, she didn't want the location read on the record, so I emailed Ms. Simpson. So she has all the information. She has his mama's address, and she has the address for the program that he will be living at. And I sent her the
program is in what state?
Nevada. Las Vegas, Nevada. Yeah, his mom and the program are both there.
So Nevada would have to agree to supervise, and it would be a condition of probation that he enter into and complete the program. And he has a place to stay temporarily, hotel, and then maybe PAD while waiting on is it called ICOTS? The ICOTS approval to have probation supervised in Nevada.
Can we make it that, like, if a condition that he enter complete if Nevada accepts him? So if some reason they don't accept him, then he can't.
And if they don't accept him, I thought he had been accepted. Meaning if Nevada accepts. Yeah. Yes. So what is plan B?
If they don't accept him, then And B would be him to get services here. He's already been accepted to PAD, then he just, I guess he could stick with the PAD services.
Okay.
But the support system is just not here, so I'm hoping he's able to leave, because
I guess what I'm going to do, besides hearing from Ms. Smith and Ms. Simpson, if we go forward in this way, is have a special condition that he enters into and completes the program. If Nevada says no, then he's not violating his probation. We'll just have to modify the revocation order to remove that requirement that he be in a program that's not in Georgia. And maybe in that interim, and he's not in custody while we are learning these things, Ms. Ross or someone from your office would be in a position to find some programming that would work. We have things like the Metro Atlanta Day Reporting Center that at least would address addiction side things, but not necessarily support on the mental health side. But I'm just throwing it out there as an idea. Your social services team may be able to identify something more comprehensive than that.
yes, Your Honor.
Okay. Mr. Kuykendall, how long have you been in custody?
Here about 2 weeks.
Just 2 weeks?
Yes.
You got picked up in California?
Oh, well, so about a month and a week, I think.
Okay. And what happened? You just walking down the street and they roll up on you, or you got a ticket and they ran your name?
I was having an issue with a security guard, and then like I had called for the police, and then they ran my name, and then I got picked up.
Oh. That must have been entertaining for the security guard. So how long ago was that?
That was about a month ago.
Okay. So you've been in custody about a month.
Yes.
All right. Have you spoken with your mother about Nevada and this program?
Yes.
What makes you think that this time around you and your mother will click in a different way? Because it sounds like some of the cycle we go through, you go through, is that you're okay and maybe you're in a good state in terms of taking medicines and whatnot, and your mom is getting along and she can be supportive, and then you guys don't get along, and then you're stuck in a situation like you were where I don't have the ability to get to this part of California because I don't have any money.
Yes.
Why would it be different this time?
I actually had a lot of time to reflect here, and while I've been in custody, and I was just being humble, and a lot of that really kind of helps me think about what I'm going to do in the future. And I've been really anxious about looking for work, and my mom has been really helpful about. We've been talking back and forth, apologizing about some of the different things that we put each other through. Well, I put her through for sure, and I just was like. Trying to be an adult and stand on my own, and I was just like, I didn't really want to move back home and have any help from my mother. I thought I could really kind of do this on my own, but it's actually really difficult.
Yes.
And so I had to kind of just release my my own pride and just become a little bit more humble and say, hey, Mom, I do really need your help. And she was like, yeah, well, I want you to be helped in this way. And so I got on the phone with her the other day. I said, with finding the programs that you're willing to entering me into with additional housing and also the medication. That was also something that I didn't really want to do at first, was take my medication, because it's very difficult to admit that you have bipolar disease when you've been going all your life without it.
Right.
Yes. So.
Okay. How is your mother able to fund these things? Does she work?
Yes, sir. So she currently works.
What does she do?
She is I believe she is the finance department supervisor over the McCarran National Airport.
Oh, okay.
Yeah, international airport.
All right. Ms. Smith, you're newer to the saga here, but based on what you've learned and heard and what Ms. Rios has tried to persuade you with, what are your thoughts as to what should happen?
Yes, Your Honor. In this case, the state took a look at the recommendation from probation. And we have just, well, not we, but the state has decided to adopt their recommendation, which is to revoke time served and to reinstate the balance. I do think the discussion that Attorney Rios and yourself just had about Plan A and Plan B is also very effective in this case. So we would just be asking to revoke the time served and to have the balance reinstated.
Okay. Lots of balance remaining. Yes, ma'am.
Since he is on mental health medication, that he, ending acceptance to, if Nevada accepts him, to continue any non-health medication treatment.
Yep. And hopefully that would be baked into the program, but independent of that, he needs to be staying current with treatment. Okay. Do you have any questions, sir?
No, sir.
All right. Well, I do find that you violated the terms of your probation by failing to report, either in California or Georgia, when they said, well, you got to go back to Georgia if you're not going to do the California thing. I'm relieved that it wasn't a new arrest or something like that. It's what we call a technical violation, but it's a pretty fundamental one because probation can't do its thing in terms of supporting you as well as supervising you if you're not meeting with them. So hopefully Nevada says yes to the transfer. If they don't, then we'll need to find you programming here in Georgia. And it sounds like your mother has the financial means to help with that. She just wouldn't be as present as personal support. And that's not insignificant to have family around. Do you have brothers or sisters or other family in Nevada or just mom?
No, I have an uncle as well, and my mom has her husband, and I have a brother. I have brothers, and I don't have any sisters.
Okay. The brothers, are they in Nevada or are they somewhere else?
I have one brother in Nevada, and I have one in Southern California.
Okay. All right. So what I'm going to do is revoke 1 month of your probation, 30 days, and then reinstate the balance. I am going to add as a special condition that you apply to the PAD program for housing and other support as long as you are staying here in Georgia. And I'm adding as a special condition that you enter into and complete. Ms. Rios is going to have to send that information to Ms. Nelson. Name of program in Nevada. Is that a residential program?
Mm-hmm.
Yes?
Yes, yeah,
Okay,
yes.
good. So you'll need to enter into that and complete it. So if you quit or they kick you out because you're doing something you're not supposed to, that's a probation violation.
Okay.
Ideally, if you're transferred to Nevada, they'll handle that. And we'll revisit what your probation will look like if you're not able to get to Nevada.
Okay.
And I guess what I should say is it's a special condition of your probation that you enter into and complete this program. I guess really it's Ms. Simpson who needs to get the name of it because she's the one who drafts these orders.
Right.
Upon your transfer to Nevada. Do you have any sense, either lawyer or client, I'm making it up, but let's say January 1, Mr. Kuykendall makes it to Nevada. I'm here. How quickly can he get into the program? January 2, is there a 6-week wait?
Says she has a bed. It seemed like they already have the housing assignment. His mom is on the Zoom. Maybe she can answer the question.
Oh, great.
Hi. Hi, Judge.
Hello.
I talked to the director over at the Elevations Behavior Center,
Yep.
and I can put a deposit down today, and he can be able to save his bed. But the thing
Okay.
is they want to interview Darian, and they would like to interview Darian in person. But I did tell him that he has to stay there until Nevada picks him up. But she said that I could put a deposit down where he has his bed there, and he can stay there. His meds and drug testing will be covered through his health insurance. They have transportation for him. He'll be doing classes. They'll be helping him look for work. It's a whole program for him, and I believe this
Great.
is the direction that Darren needs to go in.
No, I share that, and it sounds fairly comprehensive, and hopefully he's grateful that you found something like that for him. It sounds like he is. So you could basically hold his reservation by putting in the down payment, And then I guess what I'll say is that within 2 weeks of arriving in Nevada, you need to be in that program and going.
Yes.
Yeah, I would, so I'm gonna do the deposit today because I don't know how soon, I mean, before you just let him go to California and let probation happen that way. But I guess now you want him to stay there until Nevada picks him up. Is that what I'm hearing?
So yes and no. He has to stay here in Georgia until Nevada accepts supervision. They're not going to pick him up. Your son will need to get from Georgia to Las Vegas.
No, I understand that. But what I was saying, what I guess what I'm saying is, before when he was in this predicament, you let him go that same day to get back to LA.
Okay, I'm not going to do that this time. Okay. He's gonna stay here until he has the green light that Nevada will supervise him.
Okay.
Just because now there's a little history of another state's supervision not working out well. So he'll stay here. You've got him that hotel for a little while. Pad can get him some supportive housing for a little while. And it's not like it takes 100 years to get approval, but it's not instantaneous. So your son will stay here until Nevada says yes. If Nevada says no, then he hasn't violated his probation. We just need to come up with similar supportive programming in Georgia. And that exists. It's just harder for you to find it because you're in Las Vegas. You're not here. Fortunately, you've got great partners in the form of the public defender's office. They have social services experts who are finding programs like that for clients all the time. Now, they're typically looking for things that are at no cost, which are harder to get into, longer wait period, et cetera. But if your son has some financial capacity through your support, that will actually make it easier for you or for the public defender's office to identify something.
Okay.
Okay.
That works. So
Great.
would you agree, should I put the deposit down today? I just want to make sure the bed is, the room for him is held.
So I can't give you legal advice, but what I will say is if Nevada says yes to supervision, your son has 2 weeks to get into the program. And so if holding a bed makes it likely that that will happen, then that's very consistent with complying with that 2 week window. Okay. But if a month goes by and he's just sort of floating around in Las Vegas, Nevada probation should revoke him because he was given 2 weeks. So
I'll put the deposit.
Okay.
And for as where he's staying now, he needs to, I guess if you're releasing him, he'll be checking in tomorrow and I will, it will be ongoing until he gets to come back to Vegas.
Correct. Unless Nevada says no, in which case you'll do a different plan and he's not going to want to stay in a hotel the whole time. But you two will navigate that. But I'm cautiously optimistic that Nevada would say yes.
Okay.
Because they want us to say yes to people who are trying to get to Georgia.
True. Okay. Thank you so much.
Well, thank you for staying involved. This is making it a lot easier for your son.
Yes. Thank you.
Okay. Ms. Rios, anything else?
Just that we
Thank you.
make sure the order has his like a 30-day supply at least of medication.
I'm not opposed to that at all. I guess what you should do is if you get me an order, it's not really a release order. I'll hold off on signing the revocation until you can get to me an order that says when Mr. Kuykendall is released, he should be released with a 30-day supply of his meds. Yeah, it's not really a release order though. But I mean, go ahead and send that. Whatever. I don't really care what it looks like. It's just whatever you have sent in the past that says you need to release him with 30 days. It might also say transport him to stand. I can delete that part, but it's the magic language with the style of the case that says release with the 30-day supply of medication. And I'll link it to the revocation.
Judge, just to be clear, the must enter into the program within the first week of arriving.
In Nevada, yeah. So I guess it would be within 2 weeks of reporting to probation in Nevada, must enter into and then complete, and you should have the name of the program. Okay. Do you need anything else?
Hotel address? Pad address and keep them, but this is where you have the location
Oh.
where you pick up for your stuff your mom sent you.
Yes, okay, thank you so much.
When you get out,
Because
and
he
for
did
probation,
first,
you need to have
he needs to
$100
pay it
money or your mom
when he
knows
goes
about that too.
Got it. And that's $100?
Yeah, money out.
Okay.
Right, you do have to have it, I
Yeah,
forgot.
she know, your mom knows about it, she just need to give it to you.
Right. I totally-
So, yet another, financial need that you have. It's a $100 fee to process these ICOTS things. You didn't pay last time, so you're gonna need to get your hands on a $100 money order in order to have Georgia reach out to Nevada to see if Nevada will supervise your case.
Okay,
You don't need to sort that out right now, but work with your mom or anyone else. $100 money order, or they're not going to be processing your application.
okay.
Can I ask a question? Is there any way that I can do it over the phone? Does it have to be a money order? It has to come, he has to walk in with it?
I only have.
I'm getting you an answer.
Okay.
Where does it go?
The field office sends it, it's a third party.
Okay, that's sort of the clearinghouse for all the communications. Okay. Unfortunately, not everything is as modern as Apple Pay and things like that, but the money doesn't go to the Department of Community Supervision in Georgia. It goes to a third entity that is the clearinghouse for transfers in every which way in the US.
Okay.
So it's just $100 money order, and you can work with your son on how that'll happen.
And then you'll have the address, because I want to get that get that rolling right away. 'Cause
Okay.
You said that can't, he can't, they won't start nothing until that money is paid, right?
Right.
So
But
I need
it's,
that to get rolling right away.
Once it comes into the office.
they won't what?
But they say, they tell us to tell the defendants to leave it blank.
Okay, it's blank. It's $100 money order with no addressee on it. So you need to figure out how to get it to your son, and he shows up. Yeah, so as long as you get it to him, and you need to not spend it on something else.
You got it.
Take it to probation and give it to them.
So take
Okay.
it to probation, and he'll have the address and all that for probation?
No, probation will fill it. Probation knows where it's supposed to go. And I think it varies depending on the state the person is trying to transfer. All I know is you're supposed to show up with a $100 money order that's not made out to anyone.
Okay, great.
All right?
All right.
All right. Okay. Let's hope we can make this happen.
All right, thank you.
You can go back, she's gonna come talk to you.
So is there a day when he'll be released?
I
didn't hear that.
As soon as I get the release order with his medication, and he'll sign the order, then he'll be released. So tomorrow or the day after.
It'll be this week. It'll be Friday at the latest. But if I were to drop that paperwork right now to say release him tomorrow, they might not have the medication ready. We need to usually give him 24 hours so that when the inmate is being released, he is given the medication he needs.
The only reason why I'm asking is because the room is booked for tomorrow. I can extend it for him to go in on Thursday, but I did book the room because I thought at least by tomorrow he would be out. So do I need to try to extend it till will he for sure be out on Thursday? Do you know?
We don't have control over the jail, like the release, so we can't guarantee that. It should be Thursday.
Yeah, I'd be surprised if it's not Thursday. I would be surprised if it's tomorrow. I don't think it'll be tomorrow. I think it'll be Thursday. But it frustratingly for you, it's not that predictable.
Okie dokie.
All right.
All right, great. Thank you.
All right. Take care.
You too. Bye-bye.
So I think Ms. Cabrera is on with Ms. Harrigan. Maybe just barely dodging a bench warrant, but let's see.
Okay.
Everyone's into the red seats today. You noticed her seats also.
Yes, I did.
All right, so you're on, but how about Ms. Harrigan?
She should have been on. Hold on. Where is she? I'm here.
Okay, perfect.
She's iPhone. Okay. I need you to turn your video on, Ms. Harrigan. All right, there you are. Where were you this morning?
I wasn't aware we had court today.
Okay. Well, let me look your case up to make sure we're sending things to the right place.
Where's my water?
So, we send things to an address on 12 Oaks Circle in Kennesaw.
Yes, that's my dad's house, but I got a mail for January, but not one for today.
Okay. Well, we should send it to your house and not your dad's house.
I don't get mail here, so
How is that? There's no, it's like a secret address or the mailbox is gone?
the mailbox, yeah, the office is closed. It's an apartment complex. So I didn't want to put my address and not be able to receive mail. So my dad lets me know every time when I go pick the mail up, but I just didn't receive one for today.
Well, we always send them out. Now I'm gonna have to look, and if one got sent to your dad and he didn't get it to you, that's a problem. If you're gonna stay out on bond, because I know one way we can always get you to court, but that's not the way you're gonna like. Yep, one went out for this. I see the notice right here. And it was sent to 12 Oak Circle. It was sent out on November 25th.
Okay, he said he had one that he hadn't opened, but I didn't receive it, so I was.
All right, well, if he hasn't opened it, that's not real helpful for anyone, huh? You can't miss court again. If you miss court again for whatever reason, I'm gonna have to revoke your bond. These are pretty serious charges, and everyone else was able to make it, and it's a bunch of defendants, and somehow magically their mail worked. So if you're gonna stay in that apartment but don't want to use that address, then Dad's gonna need to get you all your mail when it arrives.
Understood.
Ms. Cabrera, we're moving this to the trial calendar like everyone else?
Yeah, as far as I understand, I don't think any of the co-defendants entered any pleas today. So
Nope.
we are moving to the trial calendar. I believe they all have similar offers.
I think that's right. It was all the same. So, okay, Ms. Harrigan, I'm telling you now, if you want to write it down or do whatever, you need to be in court on January 7 at 9 a.m. You will also get something in the mail, meaning it will go to your dad's house. I don't know if you'll ever see it, but I'm giving you notice now. So if you are not here on January 7th, the I didn't get it in the mail isn't going to keep you out of trouble, okay?
Okay.
All right, any questions about anything?
No, thank you.
How did you track her down, Ms. Cabrera? By phone, or did you drive out?
I called a couple of times while we were there, but it was going straight to voicemail. And then eventually she called me while I was in court in Cobb. And so I just sent her the link.
Okay.
So she returned my phone call. She called back.
All right, well, that's promising. All right, we will not do the bench warrant, and we'll see everyone on January 7th.
Thank you, Judge.
All right, take care.
Have a good one.
So I think we're done. Nope.
Almost. From the 9 a.m. calendar, position 7.
Yes.
So we discovered he is actually in DeKalb County Jail.
No
On a
bench warrant.
murder charge.
On a what?
Murder charge.
Ooh,
So he's got.
bigger fish to fry.
Exactly.
All right. So Ms. Smith, you were going to be doing some work with the co-defendant. And then I guess after you do that, you're going to figure out what to do with Ms. Faria. And then we can decide, do we want to put Mr. Lewis's case on judicial hold if he's not going anywhere in DeKalb, but we've also had it where someone is in custody for murder and the next thing you know, they're on bond and that case goes away. So I don't want to let go of Mr. Lewis quite yet, but I may do something with his bond.
Okay.
Is that the kind of thing, Ms. Simpson, you can look up also? You were able to get me information about Mr. Gates. If you could send me information about Mr. Lewis, that would be great. Thank you. Ms. Wood, anything else?
No, Judge, thank you.
All right, let me see if there is. So tomorrow, nope. Is this it? This is the last purple for, nope, we have a bond hearing on the 22nd.
Who's that?
Bond hearing is, yeah.
What? My guess is it is,
Team, it's a bond hearing presiding. It doesn't have either one of you. It's
Yeah.
Mr. Maxwell.
jump on in there, but yeah, it would have to be one of those presiding ones. I think Mr. Sharp wanted to have the prelim first because they're in such a better position to say, that's not what happened in the case. Like poor Mr. Alves, he's like, hey, so we stabbed him to death twice and it's on video. That's the only thing I've got. If between now and the 23rd, and if Ms. Nelson were sitting next to me, she'd be kicking me under the table. Something comes up where you can resolve a case or there's some agreement that gets someone out of custody, don't not reach out. Let us know.
About one. I think I have one.
You can have 10. I mean, if it's something where it's not a, hey, would you please do this, but the state opposes it, but it's negotiated.
You agreed to it.
Did I?
Yeah.
Okay, I was okay.
Don't do it right now
No, we
while I'm sitting here, but just reach out and I will figure out a way to make it happen. Ms. Nelson is enjoying, other than right now, a much deserved vacation, but we'll get the person here virtually or in person if it actually gets them out before the winter break.
Yes, and yeah, can we do if we have court Zoom because the daycare is closed all next week.
The who is close? Oh, you are unavailable.
I can do it through Zoom. You might hear some stuff in the background, but I could do it on Zoom.
I've heard that stuff before. You can do Zoom. You need to email me and Ms. Nelson and don't necessarily expect to hear back from Ms. Nelson. Here's the case and here's why it would be resolved if you can get the person in. And I'll piggyback on another judge's calendar to get the person over here or whatever. Okay, not for a suppression motion or a fourth bond hearing for someone, but this actually closes the case out.
Yes.
All right, because otherwise, see you in January. Our December numbers are going to be so poor. Thanks to that great trial. Yeah. All right. Happy holidays, everyone.
Thanks to you, Judge. Have a good one.
Same to you. Thank you.
Thank you, Ms. Jackson, Ms. Rivers, Ms. Nelson.
Have a good night, Judge.